assignments Sir has handled are of MR Lens, Ansal, Tyros, etc. Sir is also an advisor to many public and private sector banks, NBFCs, and large businesses houses on practical intricacies of IBC. He is also a member of various statutory IBC committees and visiting faculty at various seminars, webinars, including at international level held by ICAI, ICSI, CBI, study circles, associations, etc. Welcome, Manoj sir. Looking for your kind deliberations.
Thank you very much. Thanks a lot. Thank you. And, thanks to ICMI for providing us the opportunity, or especially on this particular Sunday afternoon when everybody is too busy and to be occupied in their own routine work. But despite that, they have spared time to get together here. It's a really a great privilege. It's a really a great privilege, and in fact, a great honor that people still love to learn at this age. Because why see that whenever we talk among IPs, when we talk among CS, then there is a quite possibility that you have people in the age of 30s. But in the case of IPs, it is generally around 50, 55. And despite that, having so much responsibilities of family and other things, you people are joined us. That's really good. चलिए मैं before I start my deliberation on NRRA, तो एक I have one habit of starting the things in such a way so that it gives you some sort of knowledge also. पिछले जो 10-15 दिन के अंदर, because since we people are in touch with the authorities, जब हम लोगों का एक सर्कल इस तरह से है, being president of the association, कि we do get latest information. तो पिछले जो 10-15 दिन के अंदर डेवलपमेंट्स हुई हैं उसके अंदर एक it's still only nothing official, but only a newspaper clipping that NCLT bench strength is going to be increased. It is not going to be increased by by 5 people or 10 people. It is going to be doubled, meaning thereby till date we have around 16 benches. It is going to be increased to the 30 benches, and we have 63 members, and it is going to be increased to the 115 members. तो हम सब लोग जो यहाँ पे हम especially people who we are seeing each other in video, all are eligible to be get appointed as NCLT member. It's not very tough. It's a simply, you have to simply give the interview, which are being held generally in Delhi, Mumbai, Chennai, and Calcutta also. दिल्ली तो होता ही होता है. ये सुप्रीम कोर्ट के जजेस जो होते हैं ऑनरेबल, वो लुकिंग आफ्टर IBC cases, they look into it. So if anybody of you aspire to be there, be the NCLT member, then he can have this is a good news for him. Another thing is that IBB have issued two circulars or notification. One is related to guidelines on COC, जो हम लोग सब लोग मिलके discuss करेंगे. But one funny part of it is that it is not shown in the IBB website, but it was circulated among a lot of IPs. चलिए कोई बात नहीं, हम लोग इस चीज का काफी देर से वेट कर रहे थे, तो कुछ मेरी भी इनपुट्स होंगी, कुछ आप लोगों की भी इनपुट्स होंगी, हम इसके बारे में डिस्कस करेंगे. तो दैट वी शैल डू इट अराउंड 4:30. तो यू गॉट अराउंड 2 hours टाइम, तो यू कैन थिंक एंड प्लान फॉर दैट आल्सो. और एक बड़ी छोटी थी, अभी 2 दिन पहले इनका एक 30 तारीख का सर्कुलर आया था, जहां पर उन्होंने कहा था कि डिस्क्लोजर की रिक्वायरमेंट्स थोड़ी सी स्ट्रिंजेंट करी है. इनफैक्ट वो डिस्क्लोजर रिक्वायरमेंट्स ऑलरेडी वर देयर व्हेन वी इशू आवर IM वगैरह. तो उसमें उन्होंने ये कहा कि कैरी फॉरवर्ड लॉसेस के बारे में डेफिनेटली शुड बी देयर. और इफ यू रिमेंबर अप्रोक्सीमेटली अ ईयर अगो रेगुलेशन CRP रेगुलेशन 6E के अंदर अमेंडमेंट लाई गई थी, जिसके अंदर उन्होंने ये कहा था कि आप हर क्रेडिटर्स को इन्फॉर्म करोगे. होता यह है कि many a times the government creditors especially, they don't respond, and later on they respond and say during liquidation process कि हमारा claim accept कर लो. तो this is a small thing. Now I start my actual deliberation, जो कि जिसके लिए we people all are gathered today. तो मैं जी एक मिनट अपनी जरा स्क्रीन शेयर कर लेता हूँ. Just give me a time. Yes, hopefully my screen is absolutely visible now.
Yes, sir.
This is our small introduction, and
Yes, sir, it is totally visible.
yeah, we have today workshop on not readily realizable assets. Sunday, my scheduled time is 2 to 5, and thanks to Insolvency Professional Agency of Institute of Cost Accountants of India for providing me an opportunity to interact with all my dear friends therein. तो मॉर्निंग में मिस्टर जोगेश गुप्ता जी ने ऑलरेडी 5 टॉपिक्स कवर कर लिए थे. जो 5 टॉपिक्स मेरे को दिए गए हैं कवर करने के लिए, या वो उनके बारे में मैं जरा आपके साथ शेयर कर लेता हूं. चैलेंजेस फेस्ड ड्यूरिंग लिक्विडेशन रिगार्डिंग क्लेम्स एंड इंटरेस्ट. The second topic is monetization of NRRAs. The third is treatment of NRRA during liquidation. International best practices, case laws related to NRRA, and along with that, I shall also be dealing with practical aspect of guidelines for committee of creditors issued by IBBI. That is on 6th of August, because it was of a great interest to us. अब आप लोग सोचोगे कि एक तो आज वैसे ही संडे है, एक आईबीसी और दूसरा उसके बाद आईबीसी के अंदर एनआरआरए. if we think from the quality angle, or if we think from other angle, so it's a topic which is of very depressing nature. But the fact is not like that. NRRA is not an headache for we people. It is a very, very hidden treasure, or in fact we call it as ki it is such a topic whereby you can extract a lot of money. And in fact, there has been, we people all are aware of it. Regulation 37E के अंदर हम या 38 के अंदर हम इसको कैसे यूज कर सकते हैं. तो I thought कि let's just initially to start as a motivational factor, I thought to have some success stories of the NRA and NRRA with you, so that it can motivate you and you can understand ki how big this NRA is there for we as an insolvency professionals. मैंने 3-4 प्रैक्टिकल केसेस देखे अपने सर्कल के अंदर. एक देहरादून हाईवेज के अंदर था, वेयर द क्लेम्स रन्स इनटू थाउजेंड्स ऑफ करोड़ ऑफ रुपीस, एंड थ्रू एनआरआरए ह्यूज अमाउंट वाज रिकवर्ड. सेकंड केस था मोजरबेर इंडिया लिमिटेड. इसके अंदर ग्रेटर नोएडा अथॉरिटी की एक जमीन थी जो 3,81,000 स्क्वायर मीटर की थी, रनिंग इनटू फ्यू एकर्स ऑफ द लैंड, एंड इट वाज आल्सो इसके लिटिगेशन था. इस लिटिगेशन थ्रू फ्यू करोड़ ऑफ रुपीस वर रिकवर्ड. ये सारी की सारी डिटेल्स फॉर योर रेफरेंस आई हैव ऑलरेडी गिवन देयर. थर्ड केस था एसआर फॉयल एंड टिश्यू लिमिटेड. इसके अंदर what happened is that कि my dear friend Mr. IP Anil Kohli was involved there, who was from zero he was able to recover through NRRA 21.21 crores and plus 2.86 crores also under avoidance transaction. तो मैंने मिस्टर अनिल कोहली जी को रिक्वेस्ट करी थी कि क्या नाम इसको अगर वो हैं तो हमारे साथ आके जरा इसका एक्सपीरियंस शेयर करें. तो अनिल जी आप हो?
Yeah,
Anil
I'm
Kohli?
there. Manoj ji, I'm there.
Yeah, I just give you a small introduction. He is a very close friend of mine. He has been able to recover a lot in the NRRA. So at present, he is at Spain, Barcelona. Despite that, I requested him कि नहीं, you share your experience with it, because होता ये है कि जो first mouth से आप बात सुनते हो, उसकी importance और उसकी lucidity और उसकी जो एक narration होती है, that is always very heart touching and very foolproof. So Anil ji, I hand over the mic to you. Please carry on.
Thanks a lot. Thank you.
आप अपना वीडियो ऑन कर लीजिए if comfortable हो तो.
Yeah, I'll try, but I am in a holiday kind of mood. So,
No problem. He's at Barcelona, Spain. तो चलिए आप प्लीज बताइए, स्टार्ट करिए प्लीज.
yeah.
Your
So
experience
thank you
for
very
NRRA.
much. Yeah, thanks a lot, Manoj ji, and thanks for sharing the dais, giving this opportunity to share the dais with you. And Manoj ji, I respect a lot, and more because in professionals generally we guys don't encourage doing such kind of, things with each other. But Manojji, you are really great of you. So definitely, Manojji has already explained that NRRA is a hidden treasure. And these were the right words used by him. And technicalities, I won't go into it. I'll straight away come to these success stories, because he has shared almost all the stories. I have been the part of them, and I like to definitely let know all my brothers and sisters to know how could I do certain kind of transactions wherein we realize we added value, in fact, in the things which we had lost hopes. We don't have any hope to get anything out of this. So like I start with maybe SR foils. So what happened is SR foils, so this was a closed unit since 15 years. And bank had a possession of the assets through Surfacey, and which also I had done that transaction for the banks. And then, this CRP began. We had a resolution plan, but was not approved, and it went into liquidation. And during liquidation, I put in an auction notice. And there was only one asset, basically, which was the land and building, or factory land and building and plant and machinery. So we put an auction for 21 crores itself. And during the course of the publication, when the bids were coming in, were to come in, though the RICO, this land owning agency, they issued a cancellation of lease notice. And cancellation of lease on the grounds that there are certain dues, and this lease is being cancelled, and they asked us to halt the auction. And also they issued a notice for taking over the possession, physical possession of the asset, since the lease has been cancelled. So as such, no asset existed. This was a zero asset. So then I immediately, came into action. We went to NCLT challenging that. And in the meantime, auction time was over. There were no bids. There were no bids at even 21 crores. And, so I went to NCLT. We got the stay over that. So this thing was going on. So in the meantime, this 37A came. Earlier, there was no 37A. In the meantime, when the entire process was going on, so I saw this as an opportunity. And what I did is, because there were no, precedent, and I didn't know how to move forward. So I went to NCLT to see that can I do this. I got the permission, though they gave the permission you have to take approval 3 times. Once you take, we took the approval that day. Then they said, when you receive the bids, you take an approval from us. Then when you have the highest bidder, and then you take the approval before, because NCLT was also very hesitant. So that what we did is, on receiving the approval to go ahead, and then I thought how to go about it. Should we have, what should be the basis? Because there was no base price. So I called in a stakeholders meeting, wherein we discussed the various kind of possibilities. And so the thing we concluded is that we'll go for calling expression of interest from various interested parties. So we published a notice for calling for offers of assignment of litigation rights under NRRA, because one party's assignment. However, NRRA, I would like to clarify also, you can sell the asset as an NRRA. The asset which is not readily realizable, you can sell that asset. It's not only that litigation rights are to be assigned. So these things Mr. Anand will cover during his course of his deliberations. So, what I did is I called for these offers for rights in the assets. Rights in the asset. We called it rights in the assets of the company, along with litigation's rights and the outcome thereof. So this way, so we received certain offers there. We created a process document also, how it would go, how we'll do further, all those things. And when we received the offers, we have an highest offers of around 14 crores. So 14 crore was the highest offer. So then we thought how to go to for value maximization, because there were 4-5 parties. So then the committee was of the view that we can have a Swiss challenge, and we will take this as a challenge offer, and what we call it, anchor bid. So anchor bid will be 14 crores, and then we will enhance this, ask the people to give better offer, and then the H1 will get the opportunity. So later on, what happened in the evening, I got a mail from some other person that I want to give for 14.5. You make me H1 bidder. So I thought this is Swiss challenge is really going to be very litigative. So then on my own, I just sent a mail to SCC's members that I said what we can do is I will go for an inter-se bidding, open inter-se bidding online. So, and for value maximization and also transparency. So everyone was with me for that. So we got approvals over mail and all that. So we didn't have to call the meeting. So straight away, what I did is I used the auction platform foreclosure. Not foreclosure, that Auction Tiger. So Auction Tiger, therein all the 4-5 bids which we have, we asked them to register there, and 14 crores was kept as the base price with an increase of 50 lakhs. And we asked them to have an inter-se bidding for 1 hour, and then increase like for every if a bid is received in last 5 minutes, like we do in auctions. And surprisingly, we got this final offer in inter-se bidding for 21.21 crores, which was more than the auction price when the asset was live. So this way we recovered this much from a zero asset, which was non-existent. And we sold that NRRA along with the litigation rights, and this was recovered. Then, avoidance transactions, yes, during the liquidation CRP itself, I came to know that there are 2 flats which are not shown in the this thing in the assets of the company. So these flats were sold during by the promoters before CRP, and at a very low price. So we filed an undervalued transaction. We got the valuation done, and undervalued transaction was filed under 43 and 45, sorry. And we got an order that he has to pay the balance amount out, which is the difference between the valuation we got done and what it was sold. So we recovered not 2.86, but we recovered more than that, 3.20 crores, and also plus then interest for the delayed payment. So all that we recovered in this avoidance transaction. And these were also one of the first few orders of principal bench in the beginning 2017-18 itself. So this is the story of SR Foil. Now what I'm doing, again, I have to file a dissolution. There was a matter pending. There are bank guarantees issued to the customs department. And against that asset is the, margin money kept with the bank. So I asked the custom department that, what about the guarantees? Because they had expired a long back. They were not giving this, their details. So we followed up with them, and we also filed an application with the NCLT that these bank guarantees should be realized, this FDR should be released to the liquidator being an asset. And since the guarantees have expired, though custom is not coming forward. So now, that matter being pending. So I thought, why not to realize something out of it? So just day before yesterday, we got an order. We filed an application for assignment of rights in the this margin money lying there, and also this litigation rights. So we got approval just day before yesterday from principal bench that we can go ahead for assignment of this asset also as NRRA. So now we are going to find out value in that also. So that those FDRs lying with the bank. So litigation is going on. In the meantime, customs has also filed their claim. So we are also pursuing that now, since they have filed a claim. How can they pursue, at 2 places? How can they hold the bank guarantee along with having a claim with the liquidator? So they have to forego their bank guarantee wala thing, and they will get whatever as per IBC, regarding their claim. So that way, now we are going to assign as NRRA those rights also. So in the FDRs lying with the bank. So that is also one of the mechanism where we can realize some value for the stakeholder. So there are so many things which you can do in NRA. So whatever there is, like avoidance transactions definitely is already there in the law. So whatever there is with you can try to get it assigned in as NRRA and all that. So to enhance the value. Then comes Moser Bear. So Moser Bear, so what we did is the main land 66, we sold it. So it was divided in two parts. We sold in auction, which was the land used by the corporate debtor himself. So 90 out of 94 acres, 60 acres was sold at 200 odd crores. So this was sold in the beginning itself. So later on, what I found is, there is a land piece which was converted into SCZ by the CD, which is around 32 acres, just adjoining, 66. It was called 66B. And this was a piece which was partitioned out of this 66 itself. So I thought this 30 acres again have a good value. Though what happened is it was converted into SCZ and given on lease to the subsidiary companies, Moser Bear Solar, Helios Photovoltaic. So these were given to the lease on lease. The buildings, 3 buildings had been given on lease to the subsidiaries along with the utilities. So I thought how to deal with it. So though the valuer had, given a zero value to this asset because it was leased to the, and lease was also a kind of, very long-term lease, like 90 years or something like that. So lease was also long-term lease, and security deposits were there. So, but I saw that this lease amount has not been paid for years. So there was a huge dues more than the security deposit. So I thought it appropriate that why not to try for sale as an NRRA this property along with the litigation rights, because I had filed application against the MBSL and Helios and to hand over the possession. Though I terminated the lease and I filed an application for handing over of the possession, and application was pending for years with principal bench and still pending. So I thought how to go ahead. So better is just to try for this option 37A. So I went to NCLT again and I got an order here also, and 3 times, same 3 times kind of approval by principal bench. So we got this. And here what happened is we had 7 bidders, and the price which we received was offer was for 20 crores. So again I applied the same thing, and we were able to sell this property and on as is where is, and as a NRRA, and along with the litigation rights, the property which the stakeholders never thought that they will get anything out of it, we recovered 50 crores 50 lakhs out of this asset for the stakeholders. So though the buyer, he is now handling the litigations, so later on he has substituted himself in the litigations. He will see what he can get out of it. So for our stakeholders, we got a very nice value out of this asset. So this way, we try to experiment things and try to get this thing. In Dehradun highways, as he's saying, definitely I tried for, there was a claim of NHA against NHI for compensation. So I went in for 37A. But before that, what happened is, so I had also filed an application with High Court to, since there was an clause in the agreement when this project was assigned to the CD. So there was a clause that the NHI is bound to pay at least the amount spent or the cost, and for that there was a clause that a valuer maybe or engineer may be appointed to assess what wall was put in the project by the CD, and that much was the obligation upon NHAI. Arbitration was going on in this regards, but I, as liquidator, I went to High Court, not only liquidator, but before in CRP itself, I went to High Court to direct for appointment of an engineer. So, and High Court appointed the engineer, and he assessed around 308 crores as the cost incurred by the CD. So we said now NHA is bound to give that. So a High Court ruled that yes, High Court itself ordered yes, NHA is bound to give this compensation, and we got the compensation before NHA this 37A could go, and 37A was published, but we withdrew it, and we got 300 crores, 308 crores simply from NHAI as compensation. So this way, we can use this opportunity of 37A, and there are many more things. So all this will be covered by Manoj ji. So Manoj ji, I think this is what I had to say.
थैंक यू मिस्टर कोहली, थैंक यू मिस्टर अनिल। और देखिए, होता यह है कि एनआरआई एक ऐसा टॉपिक है जिसके अंदर बंदे को ये लगता है कि हम इसके अंदर जो रेजिडुअल एसेट्स हैं उनको हम वी शुड सेल देम एंड वी मे बी एबल टू रिकवर समथिंग फ्रॉम दैट। The only purpose of asking and requesting Anil ji for this the NRI related initially introduction was that so that we should get motivated and try to understand that we have a very, very high success rate in NRRA also. I call them as the hidden treasure. I call them a wool which need to be extracted out of the sheep or from wolf or from anyone else, you can say like that. But this wool is highly valuable. When it get converted into pashmina or pashmina shawl, then it has very high value. Only thing is we need to put some efforts there. Chaliye, thank you, Mr. Anil. Thank you very much.
Thank you. Thanks a lot.
For joining us and enlightening us of how you have been able to recover crores of rupees through this 37A process. And along with that, he has also shared principal bench has been asking us to you're taking 3 steps also. तो मैं ये कहूंगा कि if anyone else among us has also another success story or something he would like to share with others before I conclude this thing there, let him come forward and share his experience also. What Mr. Anil has already said, if anything the parallel to that is there, please come and share it since it's a workshop.
Just small question to Mr. गोयल साहब नमस्कार।
हाँ जी अंजुमन जी, हाँ जी बताइए।
अनिल जी ये कुछ ये मतलब बेसिकली ना whenever you go for this NRRA sale, so is it mandatorily required to be to go for the permission from the A? Because the first half session there was a lot of confusion whether to go for the permission or not to go for the permission. So different view from the different member. Since we have already handled so many cases as you mentioned, so is it better to go for A permission, or is mandatorily required to go for A permission, or not to go? A liquidator can take his own call.
See, as per law, since there is no requirement of any permission,
yes.
But however, my cases, these were prior to the introduction of this law. That's why I went. And this is, frankly speaking, just for safer side. We do this. There is no such requirement. Manoj ji is going to cover this.
अंजुमन जी, मैं इसके बारे में आपको अपडेट कर दूं।
Okay, sir.
ये मैंने जितने भी केसेस एनआरआरए के करे हैं, मैं हर केस के अंदर परमिशन मैंने ली है। रीजन फॉर दैट इज कि बिकॉज हमारे एक बहुत बड़े बिग बॉस हैं जिनका नाम है IBC-IP, तो वी ऑलवेज हैव ए कॉर्टेसी फ्रॉम हिम एंड जस्ट टू हैव द इवैल्यूएशन ऑफ आवर ट्रांसपेरेंसी कि हम लोगों ने ये सारा का सारा एनआरआई जो बेचा है तो इसको हमने इन ए वेरी ट्रांसपेरेंट मैनर बेचा है। एक स्टेक होल्डर्स कंसल्टेटिव कमेटी हो गई, हमारे एक आर कंट्रोलर, दूसरे जब एनसीएलटी की स्टैंप लग जाती है देन नोबडी कैन क्वेश्चन टू इट। इसका एक बड़ा रीजन है उसके पीछे। व्हेन वी आर टॉकिंग इन अ क्लोज डोर मीटिंग, आई मस्ट शेयर इट विद यू कि पीपल स्टार्टेड, जैसे मिस्टर अनिल ने बताया कि हमने, कोहली साहब ने बताया कि हमने इसको एक स्टेक होल्डर्स के बेनिफिट के लिए यूज करा, बट देयर इज अदर वे अराउंड आल्सो। In many cases, it has been found, by authorities, that people have abusing this NRRA process. what they do, I just give you an example. What they do कि यानी कि नॉर्मल ऑक्शन सेल के अंदर उस पर्टिकुलर एसेट्स को बेचने नहीं देंगे और उसको एनआरआरए के थ्रू बेच के एट ए थ्रोवे प्राइसेस और एट ए वेरी रिड्यूस्ड प्राइसेस दे विल द आईपीएस वुड लाइक टू सेल दोज एसेट एंड जो भी इसके बीच में डिफरेंस होगा उसको क्या करेंगे, कैसे करेंगे, इट्स अ पब्लिक प्लेटफॉर्म, बट वी कैन अंडरस्टैंड. Just to get rid of that thing, just to just to avoid that allegation, we must go for NCLT route also. और NCLT भी सिर्फ जब भी आपको NRA की परमिशन के लिए अप्लाई करते हैं, because my advocate consultants, when I went for these NRRA sales, so they asked me कि do for that. तो उसमें at least they simply look into it कि आपने इसको नॉर्मल कोर्स में ऑक्शन के अंदर क्या एफर्ट्स करी बेचने के लिए. नंबर वन बात. नंबर दो, अब होता ही है कि जैसे फॉर एग्जांपल लेट्स टेक ए क्रूड एग्जांपल, मिस्टर अनिल जी के तो एसेट ऐसे थे कि जो क्या कहते हैं डबल या ट्रिपल प्राइस में बेच गए. लेकिन प्रैक्टिकली होता ही है कि हम इसके अंदर ये बफे ट्रांसैक्शंस बेचते हैं, जहां हम इसके अंदर सन्ड्री डेटर्स बेच देते हैं, लोन्स एंड नॉसेस बेच देते हैं, या कुछ ऐसे एसेट्स बेच देते हैं कि जिनको रिकवर करना बड़ा मुश्किल होता है. अब डेटर्स की अगर बुक वैल्यू होती है 5 करोड़ रुपया, वैल्यूअर उसकी वैल्यू करता है 5 लाख रुपया, और हम उसको बेचते हैं 1 लाख के ऊपर. तो देयर इज अ ह्यूज गैप इन दिस थिंग देयर. एंड व्हेनेवर एनसीएलटी लुक इनटू इट, अरे ये 5 करोड़ का एसेट है, इसको आप 1 लाख में बेच रहे हो, जिसको 5 लाख में बेच रहे हो, वी वोंट अलाउ यू. तो अगर नहीं अलाउ करेंगे, एटलीस्ट इफ एनी मनी कम्स आउट ऑफ दैट, इट विल गो टू द स्टेक होल्डर्स. इफ दे डोंट लॉस, it is a loss to the stakeholders, it is a loss to the creditors. So let their wisdom be prevailed, and because of that thing, at least we get saved from our transparency process. Or secondly, in my jitne mere liquidation ke, I have also handled 3-4 cases where we sold NRRA. I have been in my case also, this debtors having a book value of 5 crore, having a liquidation value of 25 lakh rupees, and sold for NRI with an advance of say 2 lakh rupees plus or on recovery 50% or something like that, the 45% something like that. Bench initially was quite skeptical. Why, Mr. Manoj, you are selling this 5 crore at this price? Then I explained to them that these are 3 years old, these are from the private parties, and what efforts I made, what I did. I'm sharing it, my experience only. What I said that, sir, I try to sell all these assets. I went for the auction of all these assets at least 3-4 times. And I, at each time I reduced price 25, 10% as is stipulated in our regulation. But I could not sell it. And now I have a don't option. I have no option. And at the same time, it was a recomposed sale on my side, that if any recovery comes out to be there later on, it will be shared with the stakeholders. So bench got impressed, and they permitted me this NRRA sale. But remember, especially he was talking about the principal benches. Principal bench in Delhi is very skeptical. If they find any hanky making that this asset is not being sold transparently and this is not being done in a proper manner, they will never grant you an NRI permission. But at least whether they grant the permission, whether they don't grant the permission, they have a better wisdom than what we have, and they know law better than what we know. At least we get saved from our later on explanation from the our regulator. So that is why practically what I said, we should go for the adjudicated authority route. Now I would request others to also share their experience and their thought, what I concluded on Mr. Anil Singh.
Thank you very much, Manojji. Thank you. Okay. Thank you.
Okay.
Bye.
ओके, तो
Bye.
बाकी लोग भी अपना एक्सपीरियंस प्रैक्टिकल शेयर करें, या उनका क्या थॉट प्रोसेस होता है. बिकॉज मैंने फर्स्ट आपका मैंने अटेंड नहीं करा, उसके लिए, बिकॉज दिस इज अ वेरी पिटिडेंट इशू. एंड दिस वर्कशॉप के अंदर हम लोग वही चीजें डिस्कस करें जब पिटिडेंट होती है. थ्योरेटिकली तो आप 37 है, 38 जब आपने आईपी का एग्जाम क्लियर किया सबको पता है. But when we face some practical difficulties and all this thing, we should, share our experiences so that, in future हमारे को इस तरह की दिक्कतें नहीं आए, और हम अपनी इसके अंदर क्या opportunities explore कर सकते हैं for value maximization, और तो that we should, should also learn. So anyone else would like to add, Mr. Madhusudan ji, you are quite senior. If you want, you can add some of your experience, or maybe others can add also.
Mr. Anand,
Yes, please.
this is Vishal Agrawal, basically.
Okay. I thought Mr. Madhusudan Sharma ji wo hain, jo hamare
Okay,
IPL
alright.
quite popular hai.
Okay,
Chaliye, okay.
anyhow, I can share my two experiences with the NRRA. One NRRA assignment we able to got just a year and a half back, and wherein UFE transactions, UFE applications were in questions. And these UFE applications were assigned to us on this sharing basis formula. At that point of time, bench was of the view that no prior permission is required from the bench, as there was no such provision at that time. Now, the bench is of the view. Just last week, I encountered another litigation in this regard. I got another assignment, and for the permission, we got the liquidator filed the application before NCLT. NCLT says that where we require that permission, that the question put up to us, to the liquidator. At that point of time, they were of the view that Regulation 37A does not require any permission from the adjudicating authority. But at the same time, Section 35 1N 1M says that power and duties of the liquidator, with the subject to the permission of the adjudicating authority, all the distribution of the assets, all the liquidation process is to be completed by the liquidator. But thereby, with this, they held that no, the permission is required from the adjudicating authority, from the NRRA. So I got these two NRRA assignments favored in our favor, and that in one of the assignment, I happily announced that we got to recover some amount to the kitty of these poor employees. Their dues were fully settled almost, and I am hopeful we will get another chunk of money, which will be paid off to other creditors. That's from my side. Thank you.
चलिए थैंक्स अ लॉट थैंक यू वेरी मच एंड चलिए अब मैं अपनी प्रेजेंटेशन को यू नो वी व्हाट आई मीन टू से वाज दैट कि वी हैव सक्सेस स्टोरीज इन इट एंड तो अगर ओनली थिंग इज वी नीड टू बी लिटिल बिट इनोवेटिव and when we are a little bit innovative तो हम लोग we can extract a very good wool out of the CD as a sheep and sell it as a pashmina in the market. Or that was my only, initially it took half an hour to motivate all of us that NRRA is a hidden treasure we need to look into. Chaliye, these were the the three things there. Ab, what culmination I have of talk with you. NRA is a very success story in some specific industries. We as a liquidator get assignments of different industries. तो इसके लिए जब मैंने इसको थोड़ा सा R&D करा तो I come across that many cases specifically where the corporate debtor is in the infrastructure sector, like construction of roads and highways, EPC, have huge outstanding unsettled or non-adjudicated claims against NHAI, steel, cement and power companies, etc., rising out of time and cost overrun, change of scope of works and non-fulfillment of covenants of underlying agreements. Therein, NRRA is very effective tool other than routine perfect avoidance data and all these transactions there. So meaning thereby learning from from my side is this, that whenever you feel that you got anything which is disputed and which will take years to resolve, sell it as an NRA. You don't know how much money you'll be able to get it, which you may not be able to set in the normal course of business because of the covenants and other strings attached to that particular asset. But selling it as NRA is something very easy. For example, I'm a liquidator at presently in one company, and what happened in that particular company that this land was sold by the bank under surfrasi, and but directors went against that sale. However, the buyer of the land has reported the money in court, but sale deed was not executed. Now he has filed a case against me that it should not be treated as part of the liquidation state. But definitely, whatever he says today, with the I filed application of the NCLT already there, with all this thing there, I be definitely selling it as an NRRA, and let the buyer be aware and take with all the disclosure that this land was sold, but the sale deed has not been executed, and amount is lying with the registry and all this thing there. I have already got a lot of inquiries from the buyer, and hopefully be successful in selling it there. So that is also part of this particular, learning from NRI sale. In routine, we always sell buffet and all this transaction. And as far as technicality of this thing is concerned, which we have already discussed, whether we could require the permission from the adjudicant authority or other this thing there, that we shall see in my later slide. And above that, Mr. Kohli, as I asked Mr. Kohli, तो ये हम लोग अपने आईपा के अंदर भी जितने भी हम फंक्शंस करते हैं, सॉरी वेबिनार्स करते हैं, we always encourage people to come forward and act as a speaker or as a moderator or help us in developing our IP economy. So आप में से भी अगर कोई anybody wants to be part of any speaker and this thing there, he can contact me. Okay, now let me move to my topic. Okay, अब इसके अंदर, I'm not aware whether Mr. Jugesh has taken this topic or not, but in my opinion, I thought of sharing with you some, we need to legally understand some things are there. What these things are there? Stamp duty on assignment. Stamp duty on assignment. Whenever we assign this particular thing there, what legal things are there? तो इसके अंदर हमारे को ये देखना पड़ेगा कि whether we are supposed to pay the stamp duty or not. Since I'm staying in Delhi under Section 37, it is stamp duty is being levied, and the stamp duty is surprisingly levied on the book value. Meaning thereby that if I'm selling my 5 crore debt, then stamp duty is being levied at the price of 1% of that particular amount, which is quite painstaking, because 5 crore रुपए का एसेट जो होता है बिकता आपका वो 4-5 लाख रुपए के अंदर है, और आप उसके अंदर जाके क्या नाम इसका वो कर देते हो. Yes, please. So, but this is a legal vision. Practically, what we do, we always enter into assignment agreement on 100 rupees stamp paper, or maybe undervalued stamp paper, and do it there. But if anything goes wrong and matter went to the court against the challenging of this assignment, which can happen for the big cases, we need our stimpers to be crossed. Stamp duty on sale of immovable asset, that is also there. But I find one interesting point herein. The interesting point here is that under SARFAESI, it is not, under SARFAESI, whenever we sell any asset, no stamp duty is paid on the fixed asset, because there we issue the certificate of sale. But no such exemption is there as far as NRRA sale is concerned. We need to knock to the authorities and tell them that that similar exemptions be extended for the NRRA sales on also. Let's see. When I was asked to deliver on this NRRA, I came across this thing just now with IBC-IP and other authorities. We shall take up this matter on behalf of our other IPs also in the days to come. GST on assignment.
So just
Okay.
just to intervene.
Yes, please.
The stamp duty on sale of immovable asset. Tamil Nadu, it is 11%, sir.
Oh my God!
Both even SARFAESI asset, you get the certificate of sale from the authorized officer, give it to the sub-register office, and have it registered on the 50C valuation. If the building is there, they will come and inspect the property and accordingly fix. It is 11.9 plus 2, sir. In metros, and 7 plus 2 in other areas.
Oh my God! Oh my God!
So this is a state subject. There is no, coordination between state and center. For this sale to go through immovable properties, I think they'll have to sit down and somebody has to make a representation with the IBBI, and they'll have to take it with the Ministry of Finance or Law and push accordingly, sir. This is the state and this is a state of affair in Tamil Nadu, sir, for your information.
Yeah, thank you very much for
Right,
enlightening me. I'm just noting it down that Tamil Nadu, the duty is so much. In Delhi, it is zero. As far as Sarfasi is concerned, whenever there is a certificate of this is given, certificate of sale is given, QS is given, nothing is to be paid there. But even then, I found it practically that whenever there is any buyer, he always go for the registry of that particular property also. I don't know why. Only an advocate can enlighten us that why he goes for the registry of that particular property, despite the fact that certificate of sale is absolutely sufficient in it. Chaliye, I come back to my
So may I add
screen
here?
sharing
May
again.
I add here?
Yes,
May
sir.
I
Yes,
add
yes.
something?
Please, please. We are here to learn from each other.
Sir, as per various Supreme Court judgments with regard to SURFACE, so there is no need of getting it registered further. So actually, as per section 17(9), I think, so it is actually mentioned that whatever actually, so we have to get whatever sales certificate is issued by the this very authorized officer of the bank. So in as regards SURFACE, authorized officer has to issue a sales certificate. So now if he issues a sales certificate, so when we provide to the revenue department, so that very revenue department is bound to actually get it entered, not registered, get it entered in the book one of the revenue department. So this has to be entered over there. An entry will be made. So wherein it will be mentioned that this very sales certificate is issued, and this will be equivalent to a change of title. So this is very much there, and various Supreme Court judgments support this very fact. And I do have some 4 or 5 Supreme Court judgments wherein even revenue department is actually categorically told that whatever sales certificate is issued under SURFACE, so that has to be entered in the book one of this very revenue department everywhere. So this is actually enforced, or I would say this is applicable on all the jurisdictions in India. So this is very much there, not only for Delhi. This doesn't mean that Delhi is the only jurisdiction wherein this very law is applicable. But this is applicable for a pan-India basis.
Sir, can you share the Supreme Court citation, sir?
Certainly, that is very
Please.
much there.
Please.
So I will be able to share, no issues on that. Moreover, various sections and various other even I would say whatever actually act is there regarding the transfer of property and various other similar allied acts actually support this very thing, and Supreme Court judgments are based on those very acts itself.
I fully endorse the view of Sandeep ji. At least the same thing I said earlier also, that it is not required. But even then, people just to have safeguard or maybe something like that, they go for registry of these properties whenever there is they buy any property under SURFACE. But I fully agree with Sandeep ji, and Sandeep ji, thank you very much for enlightening us with with your experience of with your knowledge of relevant Supreme Court judgments, which you can share in the chat box, and plus others, maybe with the organizers also later on, so that others get also enlightened, and especially from my dear friend from the Tamil Nadu, who was in a great pain of telling me that when 11% is being charged or 7.2% is being charged. Chaliye, I'm really happy that we have at least for the first 55 minutes, a very, very interactive session. I wishfully would like to, continue this interaction in my coming slides also. Let me move to share my screen again.
Sir,
To
just one point.
overcome this
Just one point,
problem
sir.
of stamp duty, it is you can go for a sale as a going concern. So in that, if you sell as a going concern, then this stamp duty is not there.
Okay, you mean to say that if you go for a sale as a going concern, the stamp, actually अब हम अपने NRI
No,
topic पे आते हैं,
I
तो,
think I think what our learned friend is talking about is, instead of registering it, since the property is in the name of the company, you just have to transfer the shares. That is what you mean, right? the share alone of the company can be transferred.
No. He's not.
Yes,
He's saying that when you sell the we have 2-3 options. We can sell the company as a going concern
Going
also during
concern.
liquidation. Then he
Exactly.
said when we sell it in a going concern, then it is not there. But our opinion is that under SARFAESI, it is not required. And Mr. Sandeep has also fortified our stand by saying this thing that this is in there. What I mean to say was that voluntarily, or maybe because of out of some fear or something like that, buyer generally get not generally intend to get it registered through registry documents also, which is not required as per our discussion is there. But as far as NRRA is concerned, there the absolutely things are absolutely clear that you have to pay the stamp duty. No exemption is there, which is our topic at present to learn. Now let's move to another GST on assignment. GST on assignment, it's basically an actionable claim. What is actionable claim? It is defined in the section 3 of the transfer TPA. As far as GST liability is concerned, you have to pay GST on assignment. What rate it will be there, that you need to consult your GST consultant to understand, because whenever you assign this particular the assignment there, it is an optionable claim, and optionable claim has been treated as goods under GST Act, and GST need to be paid until unless you are below 40 lakh exemption limit, which is a very, very rare thing there. Anybody who's we people are generally chartered accountants and other professionals. Anybody would like to deliberate on it for this particular GST aspect? Please come forward and share his wisdom with us. Okay, now I move to there. As I said earlier, that just to encourage all these things there, and just to have deal all these things more effectively, we should represent to the authorities also that some sort of exemption should also be given to the IBC companies for this particular purpose. As IBC is given a lot of exemptions after representation of government. देखिए हमारे ऊपर मैट नहीं लगता, हमारे को when we act as a liquidator section 179 में income tax के अंदर कुछ exemptions specifically हमारे को दी गई हैं. Similarly, these exemptions need to be firstly told to the regulator, and hopefully they will take up the matter with the relevant authorities, and visually these hurdles or these concessions be given to, these hurdles be crossed and concessions be given to NRRA sales to make it a very viable market. When
जीएसटी वाला प्रॉब्लम एक बड़ा प्रॉब्लम है, क्योंकि अगर जीएसटी एप्लीकेबल होता है तो लिक्विडेटर को एक अपना निज से जीएसटी का रजिस्ट्रेशन लेना पड़ता है सेपरेटली, और उसके बाद में जब जीएसटी पेमेंट करने के बाद में फिर वो रजिस्ट्रेशन फिर से कैंसिल करवाना पड़ता है. So it's a big exercise and it takes a lot of time and deliberations. So that is.
और सेकेंडली सर, मैं फाइनेंशियल एंगल से कहूँ, इस पे इनपुट क्रेडिट भी अवेल नहीं कर पाता, बिकॉज ऑल द थिंग्स आर डन एट द फैग एंड. So it's a very what in totality I mean to say is that it's a big cost. और जब भी एक पर्टिकुलर नई इंडस्ट्री डेवलप होती है तो उस नई इंडस्ट्री के अंदर इस तरह के पिटफॉल्स आते हैं which with the passage of time to encourage that particular industry these need to be removed. और मैं जब आपके साथ इंटरनेशनल प्रैक्टिसेस करूंगा तो मैं उस समय आपके साथ ये सब पॉइंट्स वहां पे डिस्कस करूंगा कि सिंगापुर के अंदर, यूके के अंदर, ऑस्ट्रेलिया के अंदर व्हाट प्रैक्टिसेस आर देयर. यू ट्राई टू सी वहां पे NRRA की बड़ी अच्छी मार्केट है. If you talk in India, it's very hard to find a buyer for NRRA. Practically, if you look into it, we are quite motivated and talking ki ye kar le wo kar le. But what Mr. Anil Puri has told, that is also good. But that is an exceptional transaction. In routine, when we go to sell perfect transactions, when we go to sell our current assets, it's a very hard nut to break practically. But this is not a hard nut as far as international practices are concerned. Our IBC law is hardly 7 years old only, or 7-year young only. With slowly and steadily, this type of market will also develop, and will definitely add a lot to the valuation. Yes, please. Anything else, or I move to my...
In case of GST payable, if the corporate debtor is already having GST registration number, then in that case it can be paid by the registration number of the corporate debtor, GST, if it is payable, like it is held that GST is payable on this. Basically, it is falling under Section 3 of that GST Act. So since it is payable, so and if the corporate debtor is having the GST registration number, then why not we pay through the use that registration number instead of liquidator taking a separate registration number for this?
In the case of liquidator, the director is no more in power. The director is there, is not there. So why will the director take this responsibility of paying it? And because whatever returns and other things will have to be filed under the corporate debtors registration, that has to be done from the director's angle, not from the liquidator. That is why it is required.
I think we are discussing a lot. Let's confine to our NRRA topic only. उत्तम जी, राकेश जी, इसके बारे में आपको ये कहूंगा कि जनरली डायरेक्टर्स वगैरह ने पास लेटर ने फाइल नहीं करी होती, as a result of which that number get blocked, and on the average we liquidator have to take new number, and for that ignoring that past defaults, department has issued a circular also whereby new number is easily given. But my concern was not like that. What happens for GST? My only concern was that because of imposition of GST, where we are not able to use that input credit, our value is declined. हमारे यहाँ पे ना एक IBC में वर्ड्स कहा जाता है वैल्यू मैक्सिमाइजेशन. वो उस मैक्सिमाइजेशन में ना एक M और A है ना, वो थोड़ा सा हट जाता है. My contentious issue we're discussing for NRA was that only. And let me with your kind concern, let me move forward and discuss my other points there.
Yes, please go ahead, sir.
Yeah. चलिए, तो हमने GST को डिस्कस कर लिया, स्टैम्प ड्यूटी को डिस्कस कर लिया. These were some negative parts of NRRA, which is not helping us in developing NRRA market in India. Hopefully, when we put all this in before the authorities, and authorities be able to implement it practically also. If it is a state subject, then among all the states, definitely this stamp duty is a state subject, GST is a national subject, and when we enlighten them, most probably they'll come out with some exemptions and all this in there, which they are coming out to be there. I'm telling you, government is helping a lot to all the IBCs. You point out to them the things that this improvement is required. They happily come forward, and because revival of industry is revival of the economy, and present government is very much optimistic. We need to revive our country with the concept of Make in India. Okay, now let's move to the forward. ये आपने सुबह देख लिया होगा. Hardly I don't need to enlighten it. Section 38 to 42 deals with it, plus chapter 5 of LP regulation, liquidation process regulation 16 से 31A है, जो इनके साथ which deals with NRRA assets. Okay, challenges faced during liquidation regarding claims and interest. Here also, being less critical and more practical, what experience we have of handling all the assignments there, I'll be sharing my experience and would like that others can also add to it, so that everybody get enlightened and get more educated after this particular workshop. First challenge I found, for this thing is there related to the claims only. What happened is that Section 38 says liquidator shall collate the claims within a period of 30 days. But many a times claims are received late, and liquidator asks for the claimant to get an order from NCLT or adjudicating authority for its acceptance of claim. Let's understand jurisprudence in this respect. I have, for enlightenment of everybody, I have noted down certain cases which I shall be sharing with you. It is in slide 14 to 15. There are 22 cases which have a divergent views. One is saying that condonation be granted whenever an application is filed before the adjudicating authority, and another set of cases says that no condonation shall be granted if there is a delay in submission of claims during the liquidation process. And then we shall reach to the conclusion that under what circumstances condonation is granted by the courts, and under what circumstances condonation is not granted by the court, so that we should be aware of it that what challenges we face during claim, and after that I have prepared 1 or 2 slides for interest also कि जो claims के साथ interest आता है इसके बारे में jurisprudence क्या है. So now let me start my this deliberation in the circumstances when condonation of delay has been granted by the honorable courts. It's a very subjective matter. It's a fact-based matter. And what are those facts that I, as per my wisdom, I'm sharing with you? NCLT Bangalore bench summarily and in a routine manner condone the delay of 1191 days. ये केस ला क्या है? ये 8 मैंने जो लिखा है, तो जब मेरी स्लाइड 14 और 15 आएगी उसके अंदर 8 केस ला के नंबर में ये आपको केस मिल जाएगा. Because while having a webinar, I always thought of clearing concept. You can't mug up case name and case all this thing there, especially until unless those are very, very landmark judgment like Rainbow, Vidarbha and something like that. But these are some routine cases. But for your reference, whenever you get stuck up for this thing there during the liquidation process, you can refer them. Similarly, the NCLT Mumbai bench in October last year condoned a delay of 451 days in submission of claims by the Department of Sales Tax with the liquidator, finding the personal medical difficulty of an officer to be a sufficient case for the said condonation. However, the bench also observed that the liquidation process was still underway and the condonation for the delay in filing of statutory claims would be in the interest of justice. This was held, in the case which you will find case number 9 in my slide number 14 to 15.
Regarding
third
claims,
case, can we do one thing that once let me conclude my this particular slides on late claim filing, and then we shall have a question answer session. Yes, it's quite possible that what your question be there that maybe get covered in my coming slides.
It is a specific question regarding claims actually under liquidation.
Okay, please come forward. Yeah, please ask.
Yes, sir. So I recently got a claim from income tax department from the assessing officer. Actually, thing is that this is from CIT appeal actually. So this is actually done on the basis of best assessment judgment under section 144, and various penalties like a penalty under section 270 271D. So those have been levied. A penalty is of 50%, then a penalty of 200%. So what they have done is actually under the best assessment judgment, they have actually disallowed all the expenditures, and moreover there is a cash deposit of 3 crore 65 lakhs, and so this is a claim of 45 crore by the income tax department. So this is a best assessment judgment. That is what my point is. So should we, and there are documents, there is a demand notice, and this is not paid by the CD, and the 30-day appeal time to CIT appeal is gone, 60-day appeal time to ITAT is gone. So should we consider this as a crystallized? Should we consider this as finalized? And in case an appeal is there and that appeal is also not decided, should I take this as a claim? Should I entertain this as a claim?
Sir, मैं बताता हूँ इसके अंदर. देखिए, once demand notice has been issued by that department, then okay, you have to accept it as a claim, whether it is under section 144, whether it is under section the penalty under 270, because once the demand notice has been issued, this is anything which is documented by the documented by some court order, that is there. As far as now, you will say that even if you have filed the appeal, that claim is still alive until unless that demand has been deleted in the appeal. And in that case, I fully understand your worriness also. Whole structure of this stakeholders consultative committee will change if you accept this particular claim of 45 crore rupees, and practically they will never come to the SEC, and all your decisions and other things will will remain pending or will go on. Financial cut has always come, but these statutory authority people sparingly come to the taking for any decision therein. But since it's backed by the orders, you have to accept it as a claim. This is my subjective opinion. others can also deliberate on it.
So, but they don't have to file a claim in proper format.
That is a technical issue. If they don't file it, then
So
as a
mere
liquidator, we
demand notice does
ask them
not.
to rectify it and correct it.
But mere
In
demand
my
notice
case,
is
actually,
not a
that is
claim.
filed under a proper form only.
Yeah, Form C, I understand, as an OC, operational character.
Yes, sir. Yes.
Or Form B or something like that.
So,
Yeah.
sir, in another case also in CIRP, again I got a claim from Income Tax Department, which is a claim of around 52 crores. So, under similar circumstances. Now, this is a CIRP. This is not liquidation.
Sir,
now these are operations.
Sir,
इसमें appeal हुई हुई ना. Now there is an appeal. The appeal to ITAT under CIRP.
Sir, अगर इसके अंदर CIT
first case, what the section 144 order, which our learned friend was talking about, I think my opinion is the first appeal has not been done, so the representation was not there, so they've gone for 144 order, and he says the cash deposit is 3 crores, but the demand is 42 crores. That cannot happen, sir. Now that the unit is under liquidation, if you're able to prove the source for this 3 crores with the income tax department, you can get away with everything. And I think we'll have to go into the facts and circumstances of the case. And once you file the appeal, CIT appeals, once that appellate stage is exhausted, only then can you go to the tribunal stage. And CIT appeals,
Certainly.
you'll have to deposit 20% of the disputed tax as deposit. So all these issues are there. So based on which he has to make a provision in the, whatever step he's going to take. So this would form part of the disputed, whatever is the disputed claim, all this, when you sell it to the, or when you're going to assign this, you'll have to factor in all this and take it forward, sir. This is my opinion.
Raghuramji, once a demand notice is issued against you, then this claim is backed by sufficient evidence from the claimant. You have to, you can't treat it as a contingent claim. You have to treat it as a main claim. No, in my subjective opinion, as per jurisprudence of claim acceptance is concerned there. Number one. Number two, getting relief of anything is not the NCLT or IBC is the platform. Getting relief is only platform is CIT appeal, ITAT, hierarchy at the income tax authorities is there. As far as concern of 144 order or 143 order, wherever any demand notice is being issued, which is backed by a particular legitimate order, this claim need to be accepted because it is backed by a particular by a court order or by a jurisdiction. No question comes out to be that should we treat it as a normal claim, should we treat it as a contingent claim? When it is backed by this particular any order, it has to be treated as a normal claim. As far as your contingent claim is concerned, you can treat it as a contingent claim only when they have not filed any claim against you, and you are aware of it through the books of account, through the balance sheet, that some note is there and something like that is there. In that case only you can treat it as a contingent claim. I remember this jurisprudence happened in one of my case of Amrit India Limited. I remember NCLT also cognized what view was taken by me there and something like that. Again, I request you, our topic is NRRA. We are moving, here and there for something understanding this thing. But it's really good that, we are able to generate so much interest in our work there. Let's move forward now, please. I was discussing that liquidation delay को कब उन्होंने condone करा, कब नहीं करा. I've discussed 3 cases where it was condoned, and what reading the whole law becomes sometimes very difficult. What those the ingredients, what vital ingredients were there, that I am sharing it in my PPT. Another was that another condonation is there, and then we more concerned with conclusion which we shall have later on. Of course, the difficulties, obstructions caused by the pandemic has been held to be sufficient count, while it has been held that this held in my case number 1110, that during pandemic any delay was there. In fact, at that time there was a Supreme Court order also whereby all delays were condoned. Okay, now come to the things when our adjudicating authority have not condoned delay of filing claim during liquidation. NCLT NCLAT have held inquiries dealing strictly with the late claim. One such instance is that the NCLT Chennai bench wherein it refused to condone the delay of 416 days in filing of the claim by rejecting the ground of not being aware of the commencement of the insolvency process and administrative difficulties, whereby it has been, what case number is that? Case number is 12. A similar decision was rendered by the NCLT New Delhi bench also, wherein the bench refused to condone the delay of 1,327 days in filing the claim by the creditor. The context was there that he said, I was not aware of the CRP process. In another instances, when one of the creditors, being the husband of a suspended debtor of the corporate debtor, filed an appeal under section so and so, and citing a reason of unawareness, the NCLT refused to condone that delay. NCLAT has also delivered few decisions refusing to condone belated claims in consonance with the scope and objective of the court, being the timely resolution of the insolvencies. Now, these were some of the cases. Now, let's reach to the conclusion that when okay, I think this is, I come back to my earlier slide. Another, another fifth case is that in this regard, it is preliminary refer the decision of the NCLT at Delhi holding that it is an axiomatic principle in law that the tribunal is required to consider the sufficiency of cause, whether the cause attributed is reasonable looking to all the facts of the matter. However, the aspect of the existence of sufficient cause is to be determined based on the facts and circumstances hovering around a particular case. Indeed, there ought not to be an inaction or want of bona fide or no negligence attributed to a litigant party, as the case may be, in continuation of delay. What this case is, this is case number 16 there, which I be sharing with you. In the context of continuation of delay, Supreme Court has held that any delay caused due to negligence or lack of vigilance on the part of the party does not and should not qualify to be a sufficient cause, and the concerned party must be able to provide cogent reason for delay to be caused. Another case I've come across whereby condonation was not allowed. The NCLAT has similarly held that a tribunal or a court of law ought to be very reluctant to excuse a delay or to lend a helping hand to a litigant who is guilty of an action, bad faith, laches, or negligence. Moreover, speed is the sense of the code, and time wasted can't be revested or regained. The process of liquidation is time bound and time bound debt and can't be recircuited. This is my case number 18. And now, the conclusive part. Similarly, there are two other more cases. One is by High Court also. An analogy of this respect can certainly be drawn from the case of State of MP versus so and so, where a special petition was filed with the delay of 663 days. The Honorable Apex Court stringently depreciated such approach of the government authorities and refused to condone the delay in the said case. It was observed that the delays can't be condoned mechanically merely because the government or a wing of the government is a party in the case, and that the law of limitation undoubtedly binds everybody, including the government. Why I've chosen this particular case is that delay in the filing claim is generally from the government department, maybe sale tax, VAT, or income tax department. And in this particular case, Honorable Supreme, the matter went up to Supreme Court. They come very heavily on the government authority that why you did not file the claim. So this I'm sharing with my friends only for the reason that it can act as a guide for them also whenever they feel that there is any they don't want to accept a particular claim because of the delay. My 8th case is the NCLT has similarly held that a tribunal or court of law ought to be very reluctant to excuse the delay or to lend a helping hand to a litigant who is guilty of an action, bad faith, laches, or negligence. Moreover, speed is the sense of the code, and so and so, so and so. Now, let me culminate all this conclusion in 2 parts. तो जो जितने भी मेरे केस लॉज हैं, these and others also, which I be sharing with you in my coming after 2 slides, that what are the basis when this condonation is allowed and when this condonation is not allowed. So we have reached to a conclusion after reading all these cases, our analysis that So it's axiomatic that the NCLT or NCLT have been taking contrasting views and have adopted varied approach to the issue of continuation of delay in filing of late claims by the creditors during the liquidation process. This no doubt keeps in ambiguity in the liquidation process and leads to an unnecessary litigation and delays. Because we were in simply in blind that whether the claim will be delayed claim will be ordered by the NCLT to accept or not. That is why this is there. Having said so, the rationale of condoning the delay in submission of claims on the ground that liquidation process has not concluded and distribution of asset is pending appears to have some force, meaning thereby that if there is a delay in claim but liquidation process is still going on, in that case claim is generally condoned. This is so far it draws the tribunals to submit to the argument of no prejudice would be caused to the stakeholders or the liquidation process. However, when viewed from a practical standpoint of view, there are various practical difficulties that have to be borne by a liquidator and the stakeholder, which have the potential of delaying the entire liquidation process if such arguments are accepted. First and foremost, the entire process of claim verification and preparation of the list of stakeholders is required to be undertaken by a liquidator within a strict timeline prescribed under the code and the liquidation regulation. But the delayed claims, when condoned by the tribunals, obligates the liquidator to revise, modify the list of stakeholders much beyond the stipulated timelines, even if the liquidation process may have reached the fag end. Not only does it bring in uncertainty in the quantum and treatment of debt out by the corporate debtor, especially when the creditor has also ceased reclassification, but also leads to the further burdening the liquidator with procedural formalities and filing of mandatory reports, intimation, so and so and so and so. Obviously, the cost to the liquidation state is defending such litigation can't also be disregarded. Meaning thereby, if I sum up my all this thing in two lines, if delay is not stop stopping there. If delay is not hampering your liquidation process, then generally courts do accept it. But if delay is hampering your liquidation process, or liquidation process has reached to such a state whereby distribution of assets have already taken place and other things have also taken place, in that case condonation is generally not allowed. And yeah, let me move a little bit more quickly. And these are the case laws which I have noted on for the reference of everybody, so that later on, if they feel they can have a relook at all these case laws. These are all related to the claims only. In some cases, claim has been condoned. In another cases, claim has not been condoned. This is for your reference. 22 case laws which I've been able to, my office has been able to R&D and putting it forward there. Okay, by now next step comes out to be there that we try to analyze the aspect of interest on claims. This is also a very big issue coming out to be there. No doubt, everybody knows it. Interest has to be calculated up to liquidation commencement date as per the terms of the contract. Nowadays, if any claim has been given during CRP period, simply the creditor can ask that this claim be increased by so much interest till LCD period, because earlier claim was filed from the commencement of the CRP. That is there. But what jurisprudence I found is there is that, but no interest on interest can be claimed even if it's claimed by the creditor. It should be declined by the liquidator as held in the case of so and so. No interest against interest is there. What is happening practically? I share my experience with you. What public sector banks are doing is that they under the public sector, even more of this private banks also, what they do is that whenever they file a claim, and since there are I call them as a COC or SCC as our parent also, because we work under them, and we as a liquidator also take a very sympathetic view of their all the deeds, they're all the doing, and we rarely delve much into verification of their claims. So we need to check all their claims, with their sanction letters. The rate of interest charged by them is proper or not. practically I found they whenever they have to file the claim, वो सारे के सारे नॉर्मल इंटरेस्ट भी लगा देंगे, पेनल इंटरेस्ट भी लगा देंगे, और उसके साथ साथ जो उन्होंने एक्सपेंसेस इनकर करे होंगे उस क्रेडिटर के ब्याह पे, चाहे वो एडवोकेट को फीस पे करने के लिए हो, इवन IRP फीस हो, आरपी फीस हो, वो भी सारे के सारे इसके अंदर ऐड करके अपने क्लेम के अंदर फाइल कर देंगे. What we need to check as a liquidator is there, whether these are they have the backing of the sanction letter or not. For example, if there is उनकी DP अगर प्रॉपर वे से नहीं निकल रही, या उनकी because of stock statement में delay है, they put some sort of pen interest on it. We need, while approving their claim, while approving the quantum of their claim, we need to check all this thing there. And in no case, what happened is that I'm just tell you with an example. किसी की 100 करोड़ रुपए की लिमिट थी, उसका एक पर्टिकुलर क्वार्टर के अंदर इंटरेस्ट लगा के अमाउंट बन गया 1 करोड़ 100 करोड़ 105 करोड़. तब नेक्स्ट मंथ के क्वार्टर के अंदर 110 करोड़, तो उन्होंने नेक्स्ट क्वार्टर के ऊपर 110 करोड़ के ऊपर इंटरेस्ट लगा दिया, which is not allowed as per law, as held by the Honorable Supreme Court in this particular case. You can charge interest only on principal amount. You cannot charge interest on interest. So we need to check this aspect whenever we verify our claim of our financial creditors, especially from the bank.
They charge compound interest, sir. Compound interest means interest on interest.
Haji, component.
As per sanction letter,
yeah,
there is a chapter provision for charging compound interest. That means interest on interest. It is not
component
simple interest.
Okay, what I found in our cases, that nothing like that component interest was there in their sanction letter. They simply said that against this particular BLR or that particular rate of interest, 5% or 7% will be there. But if it is like that, what you are saying, then naturally they are entitled for charging interest on interest. Okay. Now let me move to another aspect. Interest. I come across recently a very interesting case whereby MSME Council has awarded interest for non-payment to one creditor, MSME creditor. And I would like to, before I share my experience with it, I would like to, I'm just stopping my screen. I would like to, hear from my IPs. Do they face any such situation there? In my case, what happened, that it was a claim of a particular creditor of 80 lakh rupees, which he swallowed. If we talk about 43BH is a very popular section nowadays, whereby disallowance and all this thing it was applicable from this particular 1st of April 2024 onward. What he did is that he went to the MSME Council and said that by being a MSME registered there, I'm entitled for interest of 3 times what is the what particular rate is there. And उसने जो मेरे particular case के अंदर ये करा था कि जो 80 लाख, since it was a case of 8, 9, 10 years do get involved there, he got an order of swallowing the claim from 80 lakh to if I remember 25 to 30 crore rupees, based on the MSME orders, MSME Council's order. And have you encountered that sort of problem there? Principal amount 80 lakh rupees and balance 24 crore rupees is interest amount there. And he filed that particular claim with me. And let's share our experience. If you have faced that particular problem, based on MSME Council's order of such a huge claim, how we dealt with it. And this situation is going to be coming out very, too much now, especially after the awareness of this MSME disallowance of interest and all this thing there under Income Tax Act. हाँ जी, क्या ओपिनियन बनता है कि should I based on MSME Council's order, should I accept his claim with interest, or should I accept his claim with of principal amount only? But remember this thing, that by accepting his claim, I be causing a lot of prejudice to my other creditors also. Hopefully, I'll be able to pay them something.
So may I say something? Yes,
Sandeep ji, please.
Sir, it is always there that whatever, so what you are talking is of, I think, the operational creditor, the supplier.
Definitely.
Okay.
Yeah.
So in my cases, what I see is that what kind of contract is there with the supplier. So let us say if a contract is there, which doesn't say anything about the interest part. So let us say if maybe a purchase order is there, which doesn't say anything, doesn't mention about the interest. So in that very case, what I do is I take it on a simple interest. So whatever MSME council order is there, I think this doesn't come into picture. So we should simply go by the understanding between the CD and the supplier. Whatever understanding is there, I think for that very supplier is entitled. Moreover, like you mentioned the first case of the banker. So what I feel is, and what I have done, so whatever actually the sanction letter says in case of a bank. So if that very sanction letter says if there will be a penal interest, or if let's say if there will be compounding of interest, so I think that should be accepted, and that should be entertained by the RP or the liquidator. This is my view.
Yeah, Sandeep ji, I fully agree and endorse your view also, and I go in doing that also. But my pertinent question here is that MSME Council is a court or not? If MSME Council is a court, and if any court has given an award of a particular amount, in that case, what recourse we have as a let's talk in other way also. If he files a complaint against you that despite particular this court order, this RP has not accepted my complaint, what IBBA will ask you? What answer you have in front of the IBBA in that case? Because if
MSME is the quasi-judicial authority, and
yes.
I hope the order given by the MSME authority, MSME Council, is binding as if is an order of the court. That's my personal view.
Yeah.
Without going into the
nitty-gritty of the whole
other
thing.
court.
Yeah, because MSME Act, it starts with that particular thing. It says that it exceeds all the other acts. चलिए
no sir, finally I think this very section 238 of the IBC, this overrides all other acts which are related to recovery and everything. So I
sir,
think
वो ये 238 वहां पे override करता है जहां पे कोई conflict of interest होता है. In this case, there is no jurisprudence and there is nothing written in the law whereby it says that it is in conflict with the MSME council. चलिए मैं इसके बारे में जो मैंने थोड़ा बहुत करा है, जब मैंने जो थोड़ी बहुत R&D करी है, I just share it with you, for our benefit. Please note that what happened, the jurisprudence was there. Please note that what key points were there. Please note that IBC proceedings are not recovery proceedings, and Honorable NCLT has ignored interest awarded by MSME Council in many cases, like so and so and so and so and so. What logical conclusion they have in NCLT cases they have taken is that they have not said that IBC exceeds 238 exceeds this thing like that. They said this is the objective of IBC is to revive the company, and if we start burdening CD with so much of interest burden, maybe because of this legitimate order there, in that case revival won't be possible. And when our objective is to revive the company, we need to ignore all this thing here, number one. Number 2 point they have taken is that as far as MSME Council is concerned, the relevant underline is there that any order by the court, tribunal or something like that is there. They are not able to find their finding is like that MSME Council is a court or so and so and so and so. This matter has not been decided and is pending before some high court. Till then, it is not decided that they are not court or tribunal or some legal authority. Their decisions are not enforceable. This is the crux of in this particular case. Based on that, but this particular judgment maybe get reversed or maybe get changed in due course of time. I hope IBBI should come out with clarification considering the totality of circumstances that whether MSME Council is a this thing there is a court or not, number one. And second is that whether seeing the objective of the IBC, this 238 will come in the picture and prevail over that or not. So this is my, thought process with you. Let me move to another things here, because already 1.5 hours is devoted on it. Let's move further, please. Monetization of NRIs. तो एक हमारा ऑब्जेक्टिव ही यही है, हम बार बार वैल्यू मैक्सिमाइजेशन कर रहे हैं. वैल्यू मैक्सिमाइजेशन के अंदर अब हाउ वी कैन मोनेटाइज NRRAs देयर. इसके अंदर I would like everybody to deliberate on their experience, because there's no written law on this thing there. How we can monetize, the procedure is there, how we should monetize it, but practically what success stories are there as far as monetization is concerned. I'm sharing my experience with you. Let's move there. We know the regulation 37 says very clearly, a liquidator may, I'm reading these lines, these are very, very important lines whenever we delve into NRSL. A liquidator may assign or transfer a not readily realizable asset. This is the power given to the liquidator through a transparent process. Second point is through a transparent process. ये मैंने पहले भी बात करी है. Nowadays, NCLT look into it whether the process adopted in selling under 37A was transparent or not. So we need to have transparency in process, meaning thereby that the assets which we want to sell as an NRA, we should be able to prove to the court that we were not able to sell it in the normal course of business, meaning thereby हमने उन assets का normal course के अंदर 1, 2 या 3 या 4 बारी auction कर लिया था. In consultation with the stakeholders, consulted a committee in accordance with the regulation 31A, this is quite normal, especially after the amendment in 31A. मेरे को तो लगता है कि हर काम के लिए अब आपको SEC के पास जाना ही पड़ता है, जो हमारी 1 साल पहले 31A के अंदर amendment आई थी, या addition हुआ था. For a consideration, it's a normal, it need to be consideration. To any person who is eligible to submit a ration plan for insolvency of the corporate data, meaning thereby एक लाइन में बात करें 29A के लिए eligible हो, तो ये तो हम we do consider all this thing there. Here, my red marked ink is that through a transparent process. So this NCLT is nowadays looking after very heavily. How they are looking at very heavily, I'll be sharing it with my coming slides. This if you want to sell NRI, this process start not at the fag end of the thing there. This process start when we go for the valuation. Valuation is done under regulation 35. Here, in the case of liquidation, we get the valuation done of realizable value only. But in the case of CRP, we need to value our assets for we get the valuation of fair value and liquidation value. Although these are three apparently look like to be absolutely very seemingly, what valuer do nowadays? He will have the fair valuation of a particular thing, उससे against 20% discount करके उसको liquidation value कर देगा, and at the same time उसकी realizable value जो liquidation value को वो कह देगा, this is the realizable value also. Again, what I'm telling you is might be subjective. You may be having some of your experience also, which when I conclude this particular aspect, you can share your experience also. So when courts look after very heavily difference in realizable value and the value at which you are assigning. तो जब भी आप हमारी इनिशियली वैल्यूएशन रिपोर्ट बनाएं, तो we need to be very cautious. Especially in the case of perfect transaction, perfect में तो कोई valuation report बनती नहीं. In the case of our current asset, that the valuation is done in a very, very realizable method, so that we should not face any hurdle when we sell them under when we try to sign them under regulation 37. These are all normal things which I've already spoken and shared with you, but made it specifically in my slides to have a relook on it. Regulation 38, distribution of unsold assets. The liquidator may, with the permission of adjudicating authority, distribute among the stakeholders an asset that could not be sold, assigned, or transferred due to peculiar nature of any special circumstances. The application seek a permission to the adjudicating authority under sub-regulation 1 shall identify the asset, provide a value of the asset, details the efforts made to sell the asset, if any, and provide reasons of such a distribution. if we see the difference between regulation 37A and regulation 38, तो इसके अंदर जो biggest difference है वो यही है कि in the case of regulation 38, you need to have compulsory permission of the adjudicating authority. But in the case of regulation 37A, whether you need to have a permission or not, in my opinion, not. Theoretically not, practically yes. तो ये आपने मेरे फर्स्ट सेशन के अंदर काफी डिटेल में डिस्कस करा ही है, तो दैट इज अनदर पॉइंट फ्रॉम माय साइड. बट प्रैक्टिकली मैं आप आई हैव नॉट एबल टू सेल इवन ए single asset under regulation, sorry, not able to distribute my even a single asset to the creditors, to the financial creditors. Actually, what happens is that whenever I make an attempt to distribute my asset under regulation 38 to the financial creditors, तो उनका सबसे पहले यही आंसर होता है, सर एज ए लिक्विडेटर आप इसको नहीं संभाल पाए तो हम इसको कहां से संभालेंगे, जब हमारे पास कोई ऐसा क्या कहते हैं इंफ्रास्ट्रक्चर ही नहीं है वेयर बाय वी कैन टेक केयर ऑफ ऑल दिस थिंग देयर एंड ऑल प्रॉब्लम्स आर देयर. तो इस करके प्रैक्टिकली जो रेगुलेशन 38 है, डिस्पाइट फर्स्टली स्टेक होल्डर्स कमिटी डज नॉट अलाउ टू go to the adjudicating authority for distribution of those unsold assets. And if any one of you has been able to do successfully distribute the unsold asset, I would like to come on the screen and share his experience. At least I'm not able to do. That is why I'm asking that if anybody is able to distribute assets under regulation 38, please come forward and share his experience so that we can learn from him and apply it in our forthcoming assignments. चलिए कोई बात नहीं, it means कि the practical difficulty which I am facing is being faced by everybody, and practically this regulation 38 we are not able to use much there. चलिए now let's move to the another aspects. Okay, another practical difficulty we found is that when I got the first, I thought of selling NRA. What shall the format of the assignment date? Assignment date, if you firstly finding a prospective buyer is difficult, but if you find a prospective buyer, he will give you the assignment date which is absolutely in his favor. तो इसके लिए हम लोगों ने एक ड्राफ्ट असाइनमेंट डीड बनाई थी जो मैं आप लोगों के साथ यहाँ पे शेयर कर दूंगा. इफ यू वांट यू कैन डाउनलोड इट फ्रॉम योर चैट बॉक्स. एंड सिमिलरली इसके साथ जो जिसको हम साइन करते हैं, जो साइनी होता है, he asks for the power of attorney also. I shall share that format with you also in my chat box, or if I could not share it in the chat box, then I share it with the organizer. They can share it with you also. That we prepared the assignment date, although it is again a subjective, but it hopefully it will help you people like you. एंड फाइंडिंग, मैंने कहा था एनआरआई बायर्स को फाइंड करना बड़ा मुश्किल होता है, तो इसके लिए भी सिंस बीइंग इन आवर एसोसिएशन आई कलेक्टेड फ्रॉम मोस्ट ऑफ द आईपीज हु हैज डन दिस एनआरआई वर्क कि प्रैक्टिकली कौन कौन से बायर्स हैं एनआरआई को करने के लिए, उसकी भी एक मैंने लिस्ट बनाई है which I am sharing it with you on my screen also, and that you can that I in the chat box also, so that you can download from there for this purpose. तो ये कौन कौन से बायर्स हैं, फाइंडिंग अ बायर फॉर एनआरआई इज वेरी वेरी डिफिकल्ट. तो ये कुछ बायर्स हैं जिनको हम लोगों के साथ थ्रू whom we are able to materialize some transactions. They are working on all over India basis. So if you want, you can use their services, and any of you is having buyers, then he can also share it with me here also in the chat box, so that it can give benefit to everybody who's attending this webinar. Yes, please. I would like everybody, people to deliberate on it, their experience and all this thing there. Buyers ढूंढने में या assignment deeds के अंदर something like that. Any experience or anybody would like to share their experience in this way? Okay. I have opened up chat box. As I said, I'll be sharing my Okay, I shall share it when I finish off my this thing there. Right now, I'm not able to see the relevant button there. Okay, let me
सर
move.
चैट बॉक्स में लेफ्ट साइड में एक प्लस का मार्क आ रहा है, अगर आप प्लस मार्क को आप आइडेंटिफाई करेंगे तो वो फाइल आप उससे अटैच कर सकते हैं।
चलिए सर, मैं कर देता हूँ। राइट साइड में एक क्या आ रहा है जी? प्लस
सर लेफ्ट साइड आपके लेफ्ट साइड में आ रहा होगा,
ऊपर नीचे
नीचे की साइड से जहां
नीचे-
हम
नीचे
मैसेज
से।
लिखते हैं।
ओके ओके ओके,
जहाँ मैसेज लिखते हैं तो वहां पे सर नीचे बॉटम में या तो फाइल का मार्क आ रहा होगा।
हाँ, मैं
फोर
वही देख रहा
आइकॉन्स
हूँ।
ओवर देयर, फाइल का आ रहा है।
नहीं,
फाइल पे आप क्लिक करेंगे तो वहां पे ओपन हो जाएगा।
सर रिप्लाई में मैंने करा, अब इसके अंदर या फाइल का मार्क आ गया। यस यस सर, मैं कर रहा हूँ शेयर।
सर एक चीज और है, फॉर ऑल द पार्टिसिपेंट्स हियर, तो आई एम
You
नाउ
can share
शेयरिंग
with the institute, they will share with all the members.
सर मैंने कर दिया शेयर, अब यहीं से डाउनलोड कर लो ना।
हाँ, ऐसा कैसा करना
You know, people who are spending time and energy in attending webinar, they should have some special privilege also. Sir, मैंने कर दिया. I've shared my draft assignment, power of attorney, and you can do it there. Or I do one thing. I can share with you my if you want case laws also in detail there, because I've given you the summary only.
Sir, list of buyers also you please share. You shared the power of attorney and this one.
Ajay?
You have shared the power of attorney and the assignment deed, it seems.
Yeah, format of the assignment deed. Yes, sir.
List of buyers, sir. You have showed in the.
Sir, list of buyers is already there in PPT.
Okay, PPT you have already shared, sir. Yet to share.
Okay,
Sir, did you share the PPT?
No, I have not shared
The
my
PPT.
PPT. You want to get?
Sir, we'll share the PPT with all of the participants.
I will take the screenshot, sir. Just a minute, sir.
No, sir. Yeah, please. I know this is
Everybody will
highly
receive the PPT,
demanding.
sir.
I'm just holding it on. You can take the screenshot, or you can through your camera. You can share the photo. I know this is practically very difficult to find assignment error. Yeah, I shall share it there. But he is specifically requesting, so let me accede to his request.
No problem.
Yeah, a treatment of NRRAs during liquidation. As I said, whatever we, जितने मर्जी हम इसके गुण गालें, but NRA इसको सेल करना, NRA को आइडेंटिफाई करना, NRA को सारा कुछ करना, it's a big headache. But we are known as a registration applicant, the professional. We resolve every headache, and this headache we also resolve by learning all this in there. Try to auction based on their valuation. Already discussed. We have two types of assignments possible under regulation 37A. This we all know, but still, when I'm going for presentation, let me share it with you. The absolute assignment. The option of absolute assignment was provided to ascertain that the assignment of NRRAs will be absolute, and the assignee would have the right over the asset, and any action related thereto. The assignment would also include the transfer of all the legal rights, remedies, and power to bring the action to an end. Such can a settlement without the interface of the assigner, liquidator, data set. But this absolute assignment practically is not very popular. Reason for that is that buyer will say, I shall give you the X price, and seller will say, I don't want 2 or 3 times of X price, I want X square X. And whenever X square X, try to negotiate it with X price, it really materializes. And the best option against that is that let's share the fruit when it comes to us. At this time, it is only a tree showing us some, without any fruit. That particular process is called the assignment with recompose facility. This is more popular. The option allows the liquidator to sign the asset with an initial price. Any subsequent net recovery means the value realized less cost incurred in the recovery process of the value over and above the initial price would be shared between the assignee and the signer. I just forgot to mention here also, since liquidator is also observing and taking periodical reports from the assignee. He is also paid a particular fees also based on realization as per the terms of the assignment. Now here I stop myself. I would like to ask my participant that what market practice is going on. As far as I heard is that in most of the cases, this, if we treat it as a realization, initially we do take some amount so that assignee is bound to seriously delve into NRRA sales, and for every subsequent realization we have some share of assignments with them. Some particular portion goes to the assignee, some particular portion goes to the stakeholders consultative committee, and some very small portions goes to the liquidator as a liquidation fees. This is the market practice, what we have, what I know. And if anyone else has other practice also, please share that with us also, so that we get enlightened and do it in our future assignments.
Sir, please repeat once, sir. There was some
Mr. Chandrasekhan, I repeat again that as far as I know of market practice of selling NRI assets are concerned, here whenever we go for an assignment, we get some amount as an initial money, and after that, based on realization, we share the kitty, some amount to the assignee, some amount to the signer. Signer means SEC, and some very small portion to the लिक्विडेटर. फॉर एग्जाम्पल आई जस्ट गिव यू एन एग्जाम्पल, अगर हमारा 1 करोड़ रुपया रियलाइज होता है तो उसमें से हम कहते हैं कि 5% या 2% लिक्विडेटर को कमीशन मिलेगा, और बाकी अगर 5% हमने दी, 5% गिवन, balance is 95%, let 50% or 60% goes to the stakeholders consultative committee, the financial creditors generally, and balance 45 or 40% goes to the assignee, will be making all the efforts in recovery of monetizing that particular asset. This is the practice which I know. And if anyone else among you have another practice or can share his experience, please share for the benefit of all.
But sir, as per the regulations, so whatever liquidation fee is finalized, so maybe if that fee is not separately finalized, then there is a table over there. And as per the table, so whatever realization is done by the liquidator and further distribution is done, so liquidator is paid as per that very table. So now what you are saying is that in case of this very receipt of final amount, so some portion goes to assignee, and then also some portion to liquidator as well. But if but the liquidator will be paid as per the table only. If a separate fee structure is not there decided by the
Sandeep ji, you answered your question yourself that regulation 4A determines that what quantum of fees be paid to the there, but this quantum of fees can be overridden by having a separate agreement when liquidation process start there. So, but what I am sharing it with you, perhaps with the second proviso what you are telling.
Okay.
May I add something to it?
Yes, please. That definitely, I opened a window to understand what market practices are there.
So basically, liquidator get discharged once dissolution take place. Now, question is how the fees can be paid to the liquidator. So in assignment deeds, whatever we signed at the time of assignment, we propose a fee for observer, not a liquidator, because liquidator get discharged. Now we propose a fee to the observer of the process, and that observer can be a liquidator, can be any other person at the wisdom of the SEC. It's my view.
I fully agree with you. Actually, this is the only way. But since most of the people are doing the assignment as a liquidator, जो observer होता है generally वो liquidator ही हो जाता है. But technically, your saying is superior than what I use the word as a liquidator. It is used as an observer word only. I agree with you.
It's perfectly all right. Correct. SEC would have a comfort level with the liquidator because they have worked with the liquidator. They usually appoint liquidator as observer.
यस यस, बिल्कुल ठीक कह रहे हैं आप। अब इसके अंदर ये भाई साहब आप थोड़ा सा ये भी बता दो, जनरली रेशो अंडर व्हाट सर्कमस्टेंसेस क्या क्या होती है शेयरिंग की, सो दैट यू नो दैट कैन एक्ट एज अ गाइड फॉर अदर liquidators and insolvency professionals also.
Sir, in my view, there are so many permutation combinations. It depends solely on quality of the assets, underlying assets. If litigation is there is one instance wherein some deposits are held with the banks under guarantee. That deposits are under consideration. So certainly SCC members wants more share in that. So that can go up to 80%, maybe 70%, maybe 60%. You are right in that way. And in another case, if there are sundry debtors, one case I encountered with is there are 200 crore rupees sundry debtors. But last balance sheet filed with the available was 2017. There is no use of even a single rupee can be recovered from them. So what value you will put for them? Maybe 10%, 20%, maybe 50%. It's all negotiations amongst the stakeholders and the assignee.
Absolutely right. और इसमें हम लोग ये अब इसके अंदर मैं आपको ये बात बताना चाहता हूँ, since we are duty is to value maximization, maybe as an observer, you know, as a liquidator, तो हम लोगों को ये कोशिश करनी चाहिए कि how we can have the maximum value for our stakeholders, our creditors, financial creditors or operational creditors, by extracting maximum value from the assignee, because जो assignee होगा वो तो हमेशा कम से कम आपको वैल्यू देने की कोशिश करेगा। तो इसके लिए you may can go for some auction process also, and you may have a switch channel sort of method with the assignee also, subject to your asset is very bright and have a good saleable value in the market. And these are the practical things we need to be there, and everybody be interesting to knowing that how much generally as an observer get from all this in there. So it again varies from quantum of the quantum of the amount recoverable, and if it is running into expectation is of recovery of few hundred crores of rupees or few crores of rupees, then amount can be say 1% only. And if it is recovery of say smaller amount, or say only 100 the 1 or 2 or 3 crore rupees only, realization value only, then it can jump up to 5 to 10% here. These are the figures for which public sector banks are generally comfortable in my opinion. Number one. Number two, always try to take some upfront money from the NRRA, because until unless you don't take the upfront money from the assignee, his interest won't be there to recover all this in theirs. And this is my practical experience, along with in the name of Mr. Madhusan Sharma ji ka to maine share kar liya. If anyone else has anything else to enlighten everybody, please come forward, otherwise I move forward with my slides.
My name is
Sir, one question.
Yes sir, yes sir, please.
Sir,
my name is
okay, let him complete.
Yes, please ask your question, please.
With
Sir,
regard to this NRRA assignment, with regard to the NRRA assignment, we had made one clause where we have kept a cap of 10% as legal fees to be paid.
Okay,
and the sharing
yes,
of 90% of the fee.
Okay.
We because litigation is a very high cost in NRRA applications, so we have kept a 10% cap. Over and above that, it is borne by the assignee, and rest is divided in the ratio of 50-50, 45-45.
Yeah, that's a very good suggestion. But Sivaramanji, manage whatever cases I have handled, I never take care of any litigation cost. That in my cases, I always insist, and I've been successful also, that let it be 100% borne by the assignee, because it's a very subjective, and you can increase your share of profit in the kitty which we shall receive because of that litigation. But your suggestion is also very welcome, and everybody can take note of it and use as per their circumstances.
It is because the recoverables were only from the subsidiary company. So that was the reason.
That's good. That's good. Yeah. But thanks a lot, because that everybody get enlightened with this particular tip. Okay, ji, chaliye. In my opinion, I sum up the whole thing. Absolute assignment practically.
Sorry, one question I could not ask.
Please.
Our
Please.
distribution within SEC would be through waterfall mechanism.
हाँ जी, definitely. वो तो सर ला है, उसमें तो कुछ है ही नहीं है. चलिए, okay, for 53 तो एक ऐसा लॉ है कि जो कहते हैं ना कि some sections, some are preamble to the code, so it is one of that section, तो उसमें तो कोई thought process ही नहीं है. Okay.
I have one question.
Yes, please.
But it is related to NRRA, but it is not the process of NRRA. So if NRRA fails, we go for section 38, assigning to creditors. If none of the creditors are also not willing to take that asset, should we, one option I suggest, whether we can write off the asset and clean the balance sheet and file the dissolution application?
Sir, section 131 of the Companies Act does not allow you to write off, assets in this way, and there is no overriding section 238 as far as IBC is concerned, and you can write it off only with the order of the court only. And for getting that particular order from the court is when you get the dissolution there. That is why, in the case of liquidation companies, you are not required to prepare a balance sheet as per the Companies Act. You are only required to prepare seed and payment account.
Okay. So either 37A or 38 has to be applied for dissolution. Otherwise, we cannot.
37A, we talked about 37A, 38. It has nothing to do with the Schedule 3 of the Companies Act 2013 for preparation of balance sheet. Since you asked that question, there I remember section 131 of Companies Act is there, which does not allow you to, which does not allow you to rewrite the balance sheet of any balance sheet without the. Mr. Sudarshan, please, mute yourself. Does not allow you to rewrite your balance sheet without the order of the court, and when the dissolution orders comes out to be there, at that time you can think of, because you need to have NCLT permission for rewriting your balance sheet.
Okay, thank you.
तभी आप देखोगे ये जितनी भी लिक्विडेशन कंपनीज में सबको पता होता है कि स्टॉक जीरो हो गया है. Generally, I'm again talking practically. Despite that, you go on carrying that particular amount in your balance sheet and not writing it off. Or रही बात
in normal companies, if as per accounting standard itself, the stock has there is impairment. You have to write it off. There is impairment.
No. फिर हम लोग ना कंपनी दैट के अंदर सर हम कंपनी दैट के अंदर घुस जाएंगे. मैंने आपको ये कहा कि एक आपका लिक्विडेशन स्टार्ट हुआ 2012 के अंदर, उसके अंदर स्टॉक की फिगर आई थी 6 करोड़ रुपीस की, एंड जब आप 2014 की बैलेंस शीट बनाओगे या 2013 की बनाओगे, you won't do zero, despite the fact that there is no stock exists. Reason for the stock which get generated later on, that you can do, but as far as an earlier stock is concerned, that your accounting standard does not allow you to write it off. Only thing is you have to proceed against directors for the recovery of that particular 6 crore rupees of stock. Okay, let me move forward, please. I'm finding it very happy that along with NRRA, we are enlightening each other with a lot of other related provisions also, which we practically encountered during our liquidation or CRP process. Okay, I request again that somebody, voice is disturbing us. Let him mute himself. Chaliye. Okay. Treatment of NRS during liquidation, regulation 38, we already discussed. अतुल चोपड़ा जी, अपने आप को जरा म्यूट कर लीजिए. अब मैं थोड़ा सा सीरियस इशू डिस्कस कर रहा हूं. अतुल चोपड़ा जी, कैन यू म्यूट योरसेल्फ? ये आई रिक्वेस्ट एडमिनिस्ट्रेटर टू म्यूट एवरीबॉडी देयर. Atul Chopra ji, can you mute yourself, or I request administrator to mute everybody so that we can talk further. I think both are sleeping. Our administrator is also sleeping, and Atul Chopra is also not listening. चलिए, हाँ जी, thank you. Okay, you know what we already talked a lot about the the traditional practices through which can somebody take the responsibility of knocking Mr. Atul Chopra to mute himself?
Sir, I think administrator can do that.
Who has the power to mute? Now he can do it.
Yes.
Administrator do have the power to mute them, but I'm just calling them on phone because now I'm going to discuss with you some very serious issues, which are very innovative and which may be new to you. भैया म्यूट कर दो सब लोगों को, वो पीछे से डिस्टर्बेंस की आवाज बहुत आ रही है, उनको बोल के जरा बोलो, मैंने को कितने टाइम से कह रहा हूं कि सुन नहीं रहा. Okay, no. I have already talked with you what traditionally we can do. Now let's compare ourselves to with some international practices. Slowly and steadily, those practices will also do creep in our system also. But just to enlighten ourselves, just to understand what those international practices are there as far as NRRA sale is concerned. Let me move with those slides. Asset securitization. This is a very accepted international practice as far as NRRA is concerned. Another practice is the joint ventures or partnership. What at present, if I delve much into it, so we won't be able to understand it. It's like ERC sale of issue of tradable securities. Like I give you an example. For example, if you come across internationally, what happened is that if you come across some retail loan which has been given by a CD to a lot of people, and he sell retail loan as an NRRA to them, and it has been purchased by there are some markets in the company, which I be sharing it with you in my later stage, that in my later slides, that
So somebody else, not Atul Chopra.
Yeah, he has stopped now. This discipline we should have. I have faced this problem not only in this webinar, in all the webinars. And not only me, but everybody faces this problem that by mistake some the mic remain on, and then what happened is that when I'm talking to you, I'm talking to you by heart, and that particular voice simply pinches me in my ear.
Sir, this is the beauty of our democracy.
नहीं सर, मेरे को इसमें इतना अच्छा लगता है. देखिए मेरे यहाँ पे ना, आई एम सिटिंग इन दिल्ली एंड बहुत ज्यादा रेन वगैरह हो रही है, काफी बरसात का मौसम यहाँ पे हो रहा है. इफ यू आर पीपल स्टेइंग इन दिल्ली विल आल्सो बी नोइंग. अगर ये हमारे पास ये जूम का सिस्टम ना होता, जब पैंडेमिक के बाद हम लोगों ने जूम वगैरह का नहीं देखा, तो शायद हम लोग एक दूसरे के टच में इतना आ भी ना पाते. It's so easy, so comfortable कि you get in touch with everybody at any time, this thing है. और in fact अब तो सब लोगों की practice भी ये हो गई है. Nobody calls clients even there. Zoom पे मीटिंग करके they get concluded. जो आने जाने में आधा दिन लगता था, उसको आप आधे घंटे के अंदर खत्म कर देते. चलिए, okay.
What everybody is muted now, sir. You can go ahead.
Yeah. Asset securitization is is an internationally separate concept. मैं आपको एक इसका एग्जांपल दे रहा हूँ कि किसी सीडी का रिटेल लोन उन्होंने वो बेच दिए. अब वो पर्टिकुलर जो लोन उन्होंने जो भी एक एनआरआरए का बाहर है, मैं आपको एनआरआरए के जो बाहर है उनके नाम भी आपको बताऊंगा, उसने उसको परचेज कर लिया, और उसको परचेज करके उसके जो उसने पेमेंट करनी थी वहां पे दे हैव अ सिस्टम वेयर बाय, लाइक जैसे हमारे यहाँ पे हम लोग शेयर्स को सेल करते हैं विद द पब्लिक, जब हम डेट को पब्लिक के थ्रू सेल करते हैं, उस पर्टिकुलर चीज को क्या कहते हैं कैश उसके लिए जनरेट करने के लिए एक उसने फंड क्रिएट कर दिया जिसका टेन्योर सिर्फ होगा 4 या 5 साल का, जो कि विच विल बी रिलेटेड टू द कि उस कितने पीरियड के बीच में वो एसेट्स को जो है हम लोग रियलाइज कर लेंगे, एंड बेस्ड ऑन दैट इट्स अ विन विन, दिस थिंग इज बीइंग देयर। अब इसके अंदर विन विन सिचुएशन इस तरह से है कि एक तो जो भी पर्टिकुलर वो बायर है उसको कोई अपने पैसे नहीं लगाने पड़े, उसने पब्लिक से पैसे इकट्ठे कर लिए। पब्लिक को इसके अंदर विन विन सिचुएशन ये है, मे बी एज ए प्रमोटर कंट्रीब्यूशन मे हैव टू पुट सम मनी देयर, बट प्रमोटर के लिए ये विन विन सिचुएशन है कि अगर वो एसेट्स रियलाइज हो गए या एज पर असाइनमेंट डीड कुछ उनके बारे में हो गया तो उसको उसके जो ट्रेडेड सिक्योरिटीज है उसका प्राइस ऑटोमेटिकली बहुत ज्यादा बढ़ जाता है, एंड ही अगर उसको नॉर्मल वे से वहां पे 1 2 3 या 4% इंटरेस्ट मिलता है तो हिज मनी गेट डबल्ड इन ड्यूरिंग रियलाइजेशन प्रोसेस, बट दिस प्रैक्टिस इज नॉट प्रेवलेंट इन इंडिया। होपफुली if we enlighten our regulator and if enlighten if we start talking at least initially on this thing here, so this type of market maybe get established by the SEBI in India also, and maybe for that suggestion हमारी तरफ से आएगी, IBBI उसको एनालाइज करेगा and then they will put it forward to the regulator, and that will definitely help a lot in developing NRRA market. सेकंड मैंने आपके साथ बी पॉइंट पे लिखा हुआ जॉइंट वेंचर्स और पार्टनरशिप, देयर आर सम स्पेशलाइज्ड फर्म अब्रॉड, कौन कौन सी है इन सब की डिटेल में आपको बाद में बताऊंगा। तो उनके अंदर ये थोड़ा सा ये है कि वो जो छोटे लेवल के एसेट्स होते हैं, फॉर एग्जांपल लेट्स जैसे हमारे यहाँ पे अवॉर्डेंस या परफेक्ट ट्रांसैक्शन है, सेम कंसेप्ट इज देयर, और वहां पे कुछ छोटी फर्म्स हैं जो एक पार्टनरशिप फर्म या जॉइंट वेंचर जो सिर्फ यही परचेज करती है, या फॉर एग्जांपल कुछ इंडस्ट्री स्पेसिफिक फर्म्स हैं। इंडस्ट्री स्पेसिफिक फर्म्स का मैं आपको अगर प्रैक्टिकल एग्जांपल दूं तो वो जैसे मैंने ऊपर आपको एग्जांपल दिया रिटेल लोन का है, तो एक पर्टिकुलर फर्म है जो रिटेल लोन परचेज करती है, या एक पर्टिकुलर फर्म है जो एक पर्टिकुलर टाइप का स्टॉक ही परचेज करती है, या एक पर्टिकुलर फर्म है कि जो हु आर मसल पीपल एंड दे आर वेरी गुड इन रिकवरी, वो सिर्फ डेटर्स एंड लोन्स एडवांसेस परचेज करते हैं। तो इस तरह की मार्केट विजुअली हमारे इंडिया में भी आने वाले टाइम में डेवलप होगी, एंड देयर और ये कैसे ऑपरेट करते हैं मैंने आपको बता दिया। Collaboration with other entities can help unlock the value of NRS through shared expertise or resources. चलिए आगे चलते हैं। नो लेट मी I made my 9-10 slides on international best practices. This is I think my 4th slide there. अब मैं सर थोड़ा सा तेज मूव करूंगा, प्लीज अलाउ मी टू मूव लिटिल बिट फास्ट, क्योंकि 4:15 ऑलरेडी हो गए हैं। आई हैव ऑलरेडी टेकन योर 2 hours and 15 minutes, hardly 45 minutes are left there, और I think I have around 70 slides, and out of that only I've been able to recoup 29 slides only. Let me move little bit faster, please allow me to move little bit faster, because आपका भी Sunday है, तो I don't want you to sit extra after 5 simply to listen my boring presentation only. Okay, NRRA endeavor jurisdiction, ये इंटरनेशनल पर्सपेक्टिव दिखाने के लिए मेरे ऑफिस ने इसी करके बहुत मेहनत करी है, so that we can have a learning from them and understand कि how they are operating also. These are the only 2 objectives. इनका आज की डेट में हमारे पास शायद कोई प्रैक्टिकल इम्प्लीमेंटेशन ना हो, but it will help us a lot as far as our future is concerned. UK में इंसॉल्वेंसी लॉ आया था 1986 में, which empowers the let's understand basically how they operate. Insolvency Act 1986 empowers the liquidators to sell the property of the company. The definition of property includes things in action. There I'm also sharing with you basically what the things are there. I'm just reading it a little bit fast, please bear it with me. The definition of property includes things in action and every description of interest, whether present or future or vested or contingent, arising out of or incidental to property. It was observed in the case of earlier there was nothing like that. One famous case was there. For that particular case, whole NRA process was going on in UK. In the case of liquidator, the fruits of action form part of the asset of the company, which the liquidator must realize, and he may do so by using the power of sale of the property of the company under Insolvency Act 1986. Now let me come to the Singapore. Singapore is it's okay. It's UK. Sorry. In UK, Section 246 D of the Small Businesses, Enterprises and Employment Act 2015 permits liquidators and administrators to assign the rights of action after 1/10/2015. Here, I would like to tell you there is a very big difference in our Indian insolvency laws and insolvency laws abroad. They make if they divide the whole insolvency laws in two parts. One is of a smaller proportion and another is of other than smaller proportion. In case of insolvency laws which are applicable for smaller in proportion, जो कि हमारे यहाँ पे एक उसका थोड़ा बहुत कोरिलेटेड कहेंगे तो हमारे यहाँ पे PPIRP का कंसेप्ट आया था सेक्शन 53 के अंदर. तो वो जो स्मॉलर इन प्रोपोजिशन है उनके लिए वहां पे बहुत कम फॉर्मेलिटीज है. Very small formalities. One of my friend who's doing Sanjeev Dew is his name. He was doing international practice in insolvency laws also. He told me that in those developed countries the process is is tailor bound in such a manner that whole insolvency is being done many a times in 1 day or 2 days, 3 days, or in 7 days. This news might be shocking to you, but this is happening there. That 1, 2, 3, or 7 days, whole insolvency process is being completed. How that is completed, that we shall talk sometime else. But in developed countries, it is being done. और ये जो मैं आपको process कह रहा हूँ, ये process है ये एप्लीकेशन फाइल करने का, जो हमारे यहाँ पे सेक्शन 7, 9, 10 के अंदर फाइल होती है. वहां से लेके लास्ट में जो रजिस्ट्रेशन प्लान अप्रूव होने के बाद जो ऑर्डर आता है, और ऑर्डर ही नहीं आने के बाद उसके बाद जो डिस्ट्रीब्यूशन होता है, उस तरह से इसके बारे में ये प्रोसेस है. And in case of small businesses, I just give you an example. वहां पे पहले ही डिसाइड हो जाता है कि ये they generally call them as an administrator. Administrator पहले ही ये डिसाइड कर लेता है कि किसके साथ उन्होंने ये रजिस्ट्रेशन प्लान किसको देना है, किसने अप्रूव करना है, और उसके अगेंस्ट कितनी अमाउंट आएगा. मॉर्निंग में कोर्ट ऑर्डर करती है, आफ्टरनून में थ्रू वायर दैट पर्टिकुलर अमाउंट इज बीइंग पेड, एंड इन द इवनिंग कोर्ट आफ्टर कंफर्मेशन ऑफ द रिसीट ऑफ द अमाउंट गिव्स द फाइनल ऑर्डर. चलिए ये मैंने एक आपको यूके की यानी कि डेवलप्ड इकोनॉमी की बात बता दी. व्हाट आई टोल्ड यू इज प्रैक्टिकली हैपनिंग इन सिंगापुर. The same included a right of action for fraudulent trading, wrongful trading, transactions at an undervalue, preferences, gratuitous alienation, unfair preferences, and extortionate credit transactions. Same the way we have here. The LF2 Limited versus Superstone and another administrator of Penny Feathers Limited guides a regulator on how to conduct assignment of cause of action. Some of the following points are: an administrator's power to assign to cause of action is conferred by paragraph 2 of Schedule 1 of 86 Act. The administrator ought to be ready to investigate whether a viable claim should be preserved or pursued. If the administrator has no funds to investigate a possible claim against a third party and he receives an offer from a potential assignee of the claim to pay for an assignment, that offer will potentially constitute an asset of the company. अब सिंगापुर के अंदर जो मैं कह रहा था, व्हाट इज देयर बिफोर इंसॉल्वेंसी restructuring and dissolution act 2018 which came into effect in July 2020 after pandemic. The position pertaining to assignment of cause of action was settled in the Vanguard Energy Pte Limited case. The High Court of Singapore held that an assignment of a bare cause of action or the fruits of such actions will not be struck down if it is incidental to a transfer of property, or the assignee has a legitimate interest in the outcome of the litigation, or there is no realistic possibility that the administration of justice may suffer as a result of the assignment. In this regard, the following should be considered: whether the assignment conflicts with the existing public policy that is directed to protecting the polity of justice or the value due administration of justice and the interest of the vulnerable litigants. Here conflict with the existing public policy. ये मैं पहले इसको जरा सारा complete कर देता हूँ. अगर time रहा तो then I shall tell you what do they mean of conflicts with existing public policy. This is very important. The policy in favor of ensuring justice to this thing there. Section 144, subsection 1, subsection C of the Insolvency RDA empowers liquidator to sign the proceeds of an action arising from a avoidance transaction. The new act also allows the liquidator to enter into third-party funding agreement. The said powers, however, may be exercised by the liquidator after authorization by either the court or the committee of inspection. There they call COC, the SEC, Committee of Inspections. Australia, liquidators are empowered under section so and so to assign food so right to sue the third party. Section so and so extend the power to sign the right to sue best out on the liquidator to sue in their own name under the Act for preferential or avoidable transaction. From the perusal of, now I've summarized all this thing in what is happening in Commonwealth jurisdiction. From the perusal of all the laws of various Commonwealth jurisdiction, it is observed that England, Australia, and Singapore have clearly provided the assignments of cause of action in its legislation and authorizes liquidator to sign avoidance transaction and trading claim quickly realize on assets for the benefits of its creditors, meaning thereby कि वो भी ये same काम करते हैं. अब internationally there are many reputed NRRA buyers you are working in a diversified geographical area, and if any one of us is innovative, because NRI sale is also an innovative or have right connection, you can bring them to India also, subject to their acceptability. Who they are NRRA reputed buyer, or you can use them also. I've given you the list of Indian buyers also. But in case of some heavy assignment or assignments which are acceptable to them, you may talk to them also. I'm providing you the details of these reputed NRRA buyers also, and their jurisdiction also. Their places where they are operating. In India, they are not at all operating at present. If anyone of you knows that they are operating in India, he can enlighten us. In my opinion, they are not operating in India. Who they are? Mini Bridgeway, what key specs are there that you can look into my there, because they are very professionally oriented and work in a very professional manner. They delve into only those things for which they specializes. At present, they are working in Australia, USA, UK, Singapore, Hong Kong, Canada, Netherlands, Germany. But I hope in days to come, India, New Delhi, Mumbai, Chennai, and Kolkata, Hyderabad, Bangalore will also be included there. This is their, I've given you the address of their website. You can delve into detail. Many websites in Delhi. I don't have any connection with them. Soteria is also Soteria Investment is also a very renowned NRR buyers. Where they are operating: New York, Frankfurt, Paris, Dubai. Deminior. Belgium, Netherlands, United Kingdom, France, Germany, Spain. हमारे अनिल कोहली जी भी स्पेन में ही है, but he is not at Madrid, he is at Barcelona. Okay. Purpose of telling you all this thing is there, as an innovator or if we have a right connection, we can bring all these international NRI buyers also in India, or we can learn from them, and then we can also start operating the like ERCs for NRI buyers market also. There is no restriction at present. Only thing is, if we have a market is developing, IBC is giving a lot of opportunities for NRI sale to us. If we can develop this market, it can also be a good opportunity for us to do the diversify our activities in non-traditional way as an IP. Okay, now my another this thing is there. I was asked to deliberate on case laws related to NRRA. तो मैं अपनी घड़ी भी बार बार देख रहा हूँ. I would like to finish my presentation by 5. So I'm moving, with that speed now. There's not much jurisprudence on NRRA. Only thing is that one case is of this Sumukhi Sales Private Limited. In this case, NCLT New Delhi 5 allowed a signer, VRS Consultancy LLP, to substitute his name in the awareness application filed by the liquidator that did not delve into the purpose, etc. of the regulation. Basically, jurisprudence as far as NRR is concerned is only there where a signee many times asked to put his name, substitute his name instead of a liquidator for all the just to take care of the going on litigation. तो उसके बारे में NCLT ने क्या क्या कहा, कैसे कैसे कहा, वो हम शेयर कर रहा हूँ. Ritu Tandon versus so and so case. In this case, NCLT New Delhi 2 did not allow a signer who was Incus Fintech Private Limited to substitute his name in the avoidance application filed by the liquidator. Mr. Ashish so and so. In this case, NCLT Mumbai bench allowed the signer CRP Consultancy Services Private Limited to substitute his name in the avoidance application filed by the liquidator. TDP Copper Limited. In this case, NCLT New Delhi did not allow signer ab initio Capital Private Limited to substitute his name in the avoidance application filed by the liquidator based on the pre-positive interpretation of Regulation 37A, which says the purpose of assignment of NRRA to third party in terms of provisions of so and so is only to expedite the liquidation process and ensure disposal of the assets. They said there's no need for you to substitute, and they did not allow. Rainbow Digital Services Private Limited, Delhi High Court ने decide करा था. In this case, what happened? In this case, bar of the NRRA approached Delhi High Court for inclusion of his name as a petition under Article 226. Delhi High Court dismissed the petition, noting the matter is pending before NCLT for adjudication. The brief facts of the case are that CD sold and sent through post certain articles on cash on delivery basis. Against some sales, he received cash of rupees so and so, and some of the articles were never delivered or returned. Consequently, liquidated earlier as an IRP-RP also wrote to the Department of Post for recovery, and subsequently, he filed that particular recovery from the post he sold as an NRRA. And NRRA buyer of the this particular wants his name to be substituted. When NCLT matter was pending before NCLT, he became more innovative and filed application before the Delhi High Court invoking the Article 226, which was dismissed by the Delhi High Court. I think these are the all case laws. Now, whatever I've said till now, I'm concluding it. My conclusion is undoubtedly NRA are the black sheep for the liquidators that can make it difficult to achieve the task of completing the liquidation process in the stipulated time and spoil the pool of assets. It is prudent to give these black sheep to someone who has the resources to pull or the wool from it. In other jurisdictions, the right to transfer cause of action is covered under the definition, which includes actionable claim. The introduction of NRA had widened the scope of the cause of action that can be transferred, as it includes the transfer of contingent and disputed properties. And challenges, what we face, earlier I've told you what are my conclusion of my this thing there. Challenges what we face, we already talked, but still, as a concluding remark, currently there is hardly any market for sale purchase of actionable claim. Let's accept this fact. Contingent or disputed assets and assets underlying proceedings for profit transaction. At present, in the absence of the market, liquidator find it very difficult to assign all this thing there. In case of disputed claims, the parties will have a counterclaim, and assignment of obligation without permission of other party will always remain a challenge. Particularly, I tell you what happened, that I wrote a letter to the debtor that भैया इतने इतने पैसे आपको दूंगा, ये हमारे को भेज दो, दे दो हमारे को. I've been appointed as a liquidator, हमारे को चाहिए. तो उसके जवाब में he replied to me, and not only replied to me, to filed a counterclaim to me that not only this amount is payable by me, but this amount is receivable by me, and you include me in my FCC. Although I rejected his claim, because it was not It was not fortified with the evidences which he produced to me, but counter claims are always there, and it always is the challenge. This is all what I've already talked to you. Nothing more to say on this thing, but only thing is I have noted down or written it just for the sake of presentation. As far as challenges of NRRA is concerned, I'm moving it a bit quickly now. Okay, this is all from my side on NRRA. Now I'll be talking on practical aspect of guidelines for Committee of Creditors issued by IBBI as on 6 August 2024, because it goes to the heart of everybody. So before I move further, let me, NRRA के ऊपर अगर हम लोग आपस में कुछ डिस्कस करना चाहते हैं या कुछ डेलीब्रेट करना चाहते हैं या कुछ नॉलेज शेयर करना चाहते हैं या कुछ क्वेश्चन आंसर्स हैं, तो लेट मी टेक केयर फॉर दैट फर्स्ट.
मनोज जी, एक क्वेश्चन है.
यस प्लीज. यस उत्तम जी.
एनआरआरए का हम लोग जो आइडेंटिफिकेशन करते हैं उसको क्या सेपरेटली एससीसी में नोट करवाना जरूरी है?
सर मैं आपको बताता हूँ. देखिए, आपने एसेट मेमोरेंडम प्रिपेयर करा. जब आपने एसेट मेमोरेंडम प्रिपेयर करा तो उसको आपने एनसीएलटी में फाइल कर दिया, और जब भी आप एसेट मेमोरेंडम प्रिपेयर करोगे तो उसको आप क्या नाम इसका, डेफिनेटली दैट विल बी रूटेड थ्रू एससीसी आल्सो. अब उसके बाद आ गई एनआरआरए की बात आ गई. जब आपने एसेट मेमोरेंडम के थ्रू जो आपके एसेट्स थे आप उनको बेच नहीं पाए थ्रू ऑक्शन एंड अदर थिंग, जब आपने रियलाइज करा कि इसको नॉर्मल वे से बेचना फिजिबल नहीं है, एट दैट टाइम यू आइडेंटिफाई एनआरआरए एसेट्स. व्हेन यू आइडेंटिफाई दोज एनआरआरए एसेट्स, so definitely you need to discuss it with the SEC under regulation 31A.
सर मेरा
आप उसको
क्वेश्चन है कि
हाँ जी बताइए.
हम उसका वैल्यूएशन करवाते हैं, उसका एक लिक्विडेशन वैल्यू आया, और वो लिक्विडेशन वैल्यू से ज्यादा अगर मेरे को ऑप्शन में मिल रहा है, तो इवन इफ इट इज नॉट सपोज 10 crores of debtors is there and it is all time barred, so and the valuer is valued as 1 lakh rupees, but I am getting 10 lakhs as in the auction. So shall I have to declare it as NRI or not? That is what my question is.
No, not at all. When you are selling something above, valuation, जो valuer ने इसको valued करा है, you place it before, definitely जब भी आप auction करेंगे तो SCC की कंसर्न तो लेंगे ही ना कि मैं इन प्राइस का ऑक्शन कर रहा हूँ. जब आपको उसको 1 लाख का 10 लाख का मिल रहा तो भाई शुड गो फॉर
डेफिनेटली, क्योंकि ऑप्शन जब रहेगा तो उसका जो मिनिमम गारंटी है वो सब तो एससीसी में दैट हैज टू बी पुट फॉरवर्ड एंड दैट देयर कंसेंट नीड्स टू बी टेकन.
बिल्कुल ठीक कह रहे हो आप. तो इसमें करने की कोई जरूरत नहीं है. जनरली एनआरआर के अंदर वो एसेट्स आते हैं, जैसे आप ही का मैं एग्जांपल लूं, आपने इसको नॉर्मल ऑक्शन के थ्रू बेचने की कोशिश करी, आपने इसका मिनिमम प्राइस 1 लाख रुपए रखा, ये नहीं बिका. आपने 25% प्राइस कम करके 75,000 रुपए इसको सेकंड ऑक्शन में रखा, नहीं बिका. आपने 10% फिर इसका प्राइस कम कर दिया, 67,500 में लिखा, तब भी नहीं बिका. देन यू गो फॉर ट्रीटेड एज एनआरआरए सेइंग दिस थिंग कि मैंने इसको नॉर्मल ऑक्शन के अंदर 4 बार ट्राई कर लिया, ये नहीं बिका, लेट मी सेल इट एज एन एनआरआरए.
Here also 2 valuers required, sir.
किसमें जी?
NRRA valuation also.
नहीं, एनआरआरए की तो कुछ स्पेसिफिक, एनआरआरए एसेट्स की तो कुछ स्पेसिफिक वैल्यूएशन होगी नहीं ना. ये तो जब आपने एसेट मेमोरेंडम बनाने से पहले जब आपने लिक्विडेशन प्रोसेस स्टार्ट करा उस समय आपने एसेट्स की वैल्यूएशन तो कर ली ना. एनआरआरए की तो कोई वैल्यूएशन होती नहीं है.
पफे का वैल्यूएशन होना चाहिए.
पफे की वैल्यूएशन कैसे करोगे आप? पफे इज valuing पफे.
When we are discussing in the previous session, it was told that
पफे की वैल्यूएशन, okay, you get it done.
You need to value afresh before going for so that we need to fix the price.
Okay. That's a good that's a good suggestion. Yeah, nothing is provided in the law. If you are saying that you can get valued your perfect transaction, so please get it valued also. And as far as Uttam ji is saying ki they want to value NRA asset also, if you are willing to bear additional cost, go for that. But as far as law is concerned, nothing
there
is
is no specific. We have to appoint 2 registered valuers. My question is, even in CIRP and liquidation, we appoint 2 registered valuers. Whether a single valuation will do for NRRA asset or
देखिए एनआरआर के अंदर आपकी सिंगल वैल्यूएशन भी काम कर देनी चाहिए, बिकॉज इसके अंदर लॉ ने कुछ नहीं कह के रखा हुआ कि आपको वैल्यूएशन करवानी है या नहीं करवानी। जब लॉ ने ये कह ही नहीं रखा कि आपको वैल्यूएशन करवानी है नहीं करवानी, सिंगल का डबल का तो वैसे ही कुछ नहीं आ रहा। और वैसे भी अब जो नए रेगुलेशन आए हैं उसके अकॉर्डिंगली सिंगल वैल्यूअर ही आपके लिए काम करेगा आने वाले टाइम में।
Manoj, sir, just one question here. If you
Yes,
mention
please.
that, if you mention this asset, I think if somebody is liquidate, tried sell the asset once or twice and thrice and failed, then he can go for the application to move under NRRA. My question is that there is the asset which is under dispute from day one, and liquidator is not able to sell that asset because this is under dispute and under jurisdiction under the NCLT application moved under NCLT. Like for example, one asset which has been under hold by SEBI or maybe by ED, so I can't sell that asset. So ultimately, I have to sell. Even if I want to sell, I can sell only through the NRRA with the due permission from the AA. So in that case, without trying to sell the asset, I can straightway go to the application to move the application to AA, right, sir?
एब्सोल्युटली मिस्टर अंजुमन जी, देखिए आपका जो एसेट है ये ऑलरेडी डिफेक्टिव है। इसमें अंदर आप एप्लीकेशन में तो यही डालना है कि इसको मैं नॉर्मल वे से सेल कर ही नहीं सकता, और करने का मतलब ये है कि अननेसेसरी वेस्टेज ऑफ टाइम। तो लेट मी आफ्टर एससीसी अप्रूवल लेट मी
move an application to AA.
यस सर, बिल्कुल ठीक कह रहे हैं आप जिस एसेट की बात कर रहे हैं बिल्कुल ठीक कह रहे हैं। कोई ये रूल नहीं है कि आपको नॉर्मल ऑक्शन करना ही करना है एनआरआई सेल से पहले।
Sir, in my case, in one of my cases, actually debtors are defective. Some of the debtors are fictitious as well, and those have been valued as zero by the valuer. So let us say if I go for public auction, or maybe if I go for, let's say, NRRA thing, I have not gone for even the first public auction. So my point here is, or my query here is, what kind of reserve price should be there in case those assets are valued at zero?
रिजर्व प्राइस इस केस में अगर उसने जीरो कर रखा है तो भाई साहब आप तो रिजर्व प्राइस भी बड़ा सब्जेक्टिव सा मैटर हो गया ना, कि अब मैं इसका रिजर्व प्राइस क्या बताऊं। मेरे हिसाब से तो उसका रिजर्व प्राइस जीरो है। अब आप अपनी नेगोशिएशन करके जितना आप उससे, जैसे मैं सेम एग्जांपल, सेम थिंग हैपेंड विद मी आल्सो, इन वन ऑफ माय केस 5 करोड़ रुपए के उसके एसेट थे, 25 लाख रुपए उसने वैल्यू कर दी। क्या नाम इसका उसने, तो मैंने उसको यही करा। उसके केस मैंने आई थिंक 2 लाख रुपए लिए उससे साइडी से, और कहा कि जितने रियलाइज हो जाएंगे उसके हमारे साथ 50% हमारे को दे देना, 5% लिक्विडेटर फीस होगी, 45% आप रख लेना। अब आपके एग्जांपल का मैंने प्रैक्टिकल आंसर दे दिया। अब ये इट्स अ वेरी सब्जेक्टिव ना, यू नेगोशिएटेड इंक्लूड अकॉर्डिंग लाइक जला दो।
So one suggestion on this query from Mr. Sandeep.
Yes, please, Sangaradhan, please.
So if there is a no valuation, can we take the approval of SEC for deciding the reserve price?
Please come again, Mr.
Sir, actually, when there is no valuation, the valuation is assigned as zero. Can we take the advice of SEC as per 31A regulation for fixing the reserve price instead of we fixing the reserve price?
सर एससीसी आपको यही कहेगा, आईपी साहब आप हमारे से ज्यादा जानते हो, आप खुद ही डिटरमाइन करो इसका। हाँ, आप अपनी तरफ से डिटरमाइन करके प्रपोजल उनको दे सकते हो।
हाँ,
certainly. So this is actually the prerogative of liquidator only. So in this very case, yes, in this very case, this is quite subjective, as
since it is subjective, we can place before SEC for approval. So that
generally SEC doesn't come forward for such advices.
चलिए, anything else, or should we move to our lovable topic of COC guidelines?
Sir, one more thing.
Yes, Sandeep ji, yes, please.
While Mr. Anjum also asked regarding a defective title. So in my case, actually, that very asset is not shown in the balance sheet because of the defective title, and that is not valued. While going through the process of liquidation, I found out that certain documents are there, or I could find out, I could lay my hands on certain documents that a power of attorney is there in the name of the company, and that very asset actually is not disclosed in the balance sheet of the company. But there is a big farmland, its title is defective, it is the disputed property. Somebody else has also laid claim on that very big chunk of land. So now this is not valued. this is it has got a defective title. So obviously I want to go for NRRA under section 37A. Now this has to be valued. This has to be valued by some valuer so that I can get a reserve price.
सर मैं सेम आपको इसका एक एग्जांपल देता हूं. हमारे एक केस के अंदर ये हुआ, हमने जैसे जनरली नॉर्मल में हमने सिक्योरिटी चेंज करते हैं, हमने सिक्योरिटी चेंज करी. जैसे ही हमारा वहाँ चौकीदार था, तो चौकीदार ने हमारे को बताया, साहब आपकी तो ये ना इन मालिकों की ना कुछ और जमीन भी यहाँ पड़ी हुई है. सेम थिंग, यू नो, when we came to know about that, we also delved, you know, into it, and same situation जो आपने बात करी वही आई. अब इस केस के अंदर आपको डेफिनेटली वैल्यूएशन करनी है, बिकॉज यू नो इट सेड इन आवर एज अ लिक्विडेटर, वी आर नॉट ओनली कंसर्न्ड ऑफ सीइंग द एसेट व्हिच आर अवेलेबल इन द बैलेंस शीट, वी आर कंसर्न्ड विद ऑल द एसेट. डेफिनेटली अब आपको पहले पता नहीं था, तो आप कैसे उसकी एक महीने के अंदर वैल्यूएशन करवा लेते अंडर रेगुलेशन 35. व्हेन यू केम टू नो, यू गेट इट वैल्यूड, सो दैट डेफिनेटली यू गेट इट वैल्यूड.
ओके सर, थैंक यू सर.
Sir, whether we need to follow Schedule 1 of the liquidation regulations, sir, for giving a e-auction process?
डेफिनेटली सर, ऑक्शन के लिए तो हमारे को शेड्यूल 1 फॉलो करना ही पड़ेगा ना. उसके अंदर बड़ा क्लियर वैसे लिखा हुआ है, टाइमलाइन इतना टाइम देना आपको, एक ऑक्शन दूसरे ऑक्शन के बीच में इतना टाइम का डिफरेंस होना चाहिए, प्राइस रिडक्शन जो है 25%, 10% होनी चाहिए. वी नीड टू डेफिनेटली फॉलो दैट. और अगर आप नहीं करोगे ना, तो अगर कल को बात एनसीएलटी में पहुंच गई या आईबीबी में पहुंच गई, तो फिर थोड़ी सी परेशानी आ सकती है एज ए लिक्विडेटर आपके ऊपर. या अगर जब आप डिसोल्यूशन एप्लीकेशन फाइल करोगे, फॉर्म H फाइल करोगे, तो अगर जनरली वैसे बेंचेस ज्यादा डेल्व नहीं करते, बट इफ एनीबॉडी डेल्व इनटू इट और सम सॉर्ट ऑफ ऑब्जेक्शन केम आउट अगेंस्ट दैट पर्टिकुलर थिंग, यू नो, समबडी फाइल्ड अ कंप्लेंट अगेंस्ट यू कि आपने इसको क्या कहते हैं अंडर वैल्यू पे बेच दिया है, या आपने इसको प्रॉपर प्रोसेस नहीं फॉलो करा, योर होल प्रोसेस विल बी thoroughly examined, and my only submission is that we should strictly follow relevant regulation and Schedule 1 when we go for the auctions. Yes, sir.
Sir, when some section 19(2) application is still pending against the promoter, normally what happens, they don't share any of the documents. That is why it is becoming NRRA. for debtors, inventories and everything, they are not sharing any documents. Even for receivables from statutory, they are not sharing any documents. That becomes NRRA for the liquidator without the absence of any documents. What happens to section 19(2) after we assign the documents? Whether it can also be assigned along with the case, or it should be dealt by the SCC?
Sir,
any practical example?
Sir, you are the king. You decide whatever you want, you do for that. Generally, it is also signed, because after completion of liquidation or you know, after filing of dissolution application, no liquidator want to carry any headache along with him.
Sir, I'm Sudarshan here.
Yes, please. Yes, please.
I'm in a case of liquidation wherein there are 3 assets which are can be grouped under NRRA. That salient features are like this. The 2 assets where they have built constructed the building without any plan from the local development authority or the municipal authority. And second thing is there is a demolition order for demolishing the building with our own cost, with the CD's cost. That also they have not done, and they have not given any power connection. They have not given any water connection. No, they have not recognized the building. This is one. And second thing is they have encroached the railway land about 30 meters. So that notice is also there. So with this, we are unable to sell the asset. When we refer this to SEC is outrightly rejecting. This cannot be NRRA. We cannot group it. It will impact our officers' career and other things, and all. It will refer to our own credibility of assessing the asset. We cannot approve this as an NRRA. You keep trying. We cannot approve this. We cannot take it as an NRRA. And our third asset is where the Raj Kalway is there, the high tension is going above the thing, and nobody is coming for buying those assets. Same CD. But SEC is not allowing me to group it as NRRA. What is the solution, sir, in this case?
Sir, you file an application with the NCLT for extension of your liquidation period, which 1 year से अब ऊपर होगा. जब 1 या 2 या 3 बारी वहां पे एक्सटेंशन करोगे, अब हर बारी यही रीजन दोगे उनको कि मेरे को एसएससी इन एसेट्स को बेचने नहीं देती, और जब तक मैं इनको बेचूंगा तो मैं डिजिटल एप्लीकेशन फाइल कर पड़ता. तो एनसीएलटी जो कोर्ट है अपने आप एसएससी मेंबर्स को वहां बुला लेगी और उनको बोलेगी भाई what happen is that whenever you एक कहते हैं ना, जब आपके सामने एक बड़ा भाई आ जाए तो उसको मोल्ड करने के लिए you need to have his big brother. That's all.
Sir, I have a sir. I
Yes,
have
yes,
a,
Parveshan ji, chaliye
can
please. हाँ, yeah. Yes, yes, please.
Sir, I am Nair from Cochin.
Yes, please.
Sir, I have an asset for acres of land. I have an e-auction advertisement made for 11 times. And this land is under a sham deal in somebody else's name.
Yes, sir.
And but it is mortgaged with the bank. It was now assigned to ARC. Now I am trying to sell it as, transfer or assign it as NRRA. No stakeholders are interested to take it also. Can I go ahead and do it? Whether NCLT can remove the sham deal. Otherwise, the sub-registrar may not allow the registration.
Sir, अब देखिए आपकी from your talk I can understand 2 things. One is that this land does not belong to the CD, but because it is not registered in his name, but somehow it is coming in your balance sheet and it has been mortgaged by the CD to the debtor and subsequently purchased. CD by CD to the financial creditor, and it has been purchased by the ARC. You in your hand nothing is there. You have to explore some buyer, some assignee whom you have to sell under all these disclosed circumstances that this is not in their land there. Say for example, the market price of that land is 50 crore rupees, and if some assignee come forward to you and say that I shall give you only 5 lakh rupees upward, and then if I get this land based on the market price, I shall share the proceeds with you, maybe 50%, 40%, 60%. You have to go for that only. But remember empathetically that till you are not able to dispose of this particular land, you can't file the dissolution application. And if you, after every 1 year completion of 1 year, you need to file an for extension application with the NCLT. Put this problem in front of the NCLT that this is the reason I want extension. And what you're saying is that need to seek a permission from the NCLT or not. Definitely that aspect will be covered there when you file the extension application.
सर ये PUFE ट्रांजैक्शंस का कुछ सक्सेस स्टोरीज हो तो बताइए.
सर उसके लिए आपको फॉरेंसिक ऑडिटर को पॉइंट बुलाना पड़ेगा वेबिनार के लिए. What success story I can share with सर एक मिनट इनकी मैं एक स्टोरी बता देता हूँ. एक मेरी फ्रेंड है पूजा बेरी करके, and my professional colleague is there. For perfect transaction she went up to Supreme Court. अभी मेरे को उसका केस का नाम याद नहीं है. मैंने लास्ट ईयर मैंने जब सिंगापुर में डेलीवेशन किया था ये फॉरेंसिक ऑडिट के ऊपर, तो मैंने I named that record there. You can search into Google, and definitely she was very successful. NCLT, NCLAT और ultimately Supreme Court से definitely वो तो हर प्लेटफॉर्म पे जीती थी. और उसके बाद जो कॉर्पोरेट डेटर था वो गया था वहां पे defending his, went to NCLAT and Supreme Court, and everywhere he lost it. So that is a very big success story. Based on that, अगर आपकी कोई practical problem है अपने facts के साथ correlate करके, you may be able to find some clue therein. Yes, please.
Sir, this onerous property under regulation 10. Onerous property, there is a regulation 10.
So sir, onerous property में तो बड़ा clear कहा हुआ है कि if there is any onerous property, you get rid of it. onerous property mean that his maintaining cost is more than what realizable value expected from that. In the case of onerous,
realization is less and the expenses to be maintained.
yeah, expenses. You can, as far as onerous property is concerned, you can always leave it, exclude it from your liquidation estate
by filing application.
Yeah.
Sir, in our case, CD has imported some goods on Bombay port around 8-9 years before. So 2 times notice has been issued by them that you have not released the property, hence we are auctioning it. So we got a mandate from the NCLT court that custom authority will not sell it off, rather hand it over to the liquidator or the CIRP person.
Exactly.
But we could not get these goods even inspected, even after getting a lot of chase before the authorities. So what kind of a property it will be considered as onerous, or you are?
Definitely, in my opinion, it is not an onerous property. You move an application before the NCLT, praying them that custom authorities are not handing over the assets to them. What should happen is that they should hand over the assets to you, and whatever dues against custom they have, they should file a claim against that. This is a settled law up to Supreme Court. That is there, and wherever you feel handicap of any of such thing, our big brother NCLT is always helping us. You file an application before the NCLT, praying praying for the direction to the custom authorities to hand over the goods to them.
So we have done like that only, but so
Yes.
far we are not able to ascertain whether the goods are still lying over there or not. We made a diligent efforts over there 2 times, 3 times at Bombay ports, but nobody is agreeing that whether the goods are still exist or they had already disposed of. We have a mandate from NCLT. Even then, we cannot get success over there.
Sir, it is the duty of the custom authorities. Whenever they confiscate any goods, they are responsible for the custody of that assets. And if when they are not able to give you the location and all this thing there, onus is not on you. Onus is on the custom authorities. And if custom authorities are failing, whatever application you have filed earlier, continue that application and say that custom authority is not able to give us all these assets or identify all these assets to us. Please direct them for appropriate directions.
सर इसमें आप कस्टम अथॉरिटीज के अगेंस्ट उसमें भी जा सकते हैं कंटेम्प्ट पिटीशन के लिए, या फिर आप रिट जुरिसडिक्शन भी एक्सप्लोर कर सकते हैं इसमें.
Yeah, you can exercise. It is basically the responsibility of the custom authorities to have the safe custody with them and hand over to you. And if they are not able to hand over to you, you exercise all the possible legal remedies with you. Or sir ने ये कहा बिल्कुल ठीक कहा कि you go for the writ petition all this thing there. But that if you have the money to go for all this thing there, but NCLT route तो आपको लेना ही लेना हर हालत में for that directions.
Sir, in case of these buffet transactions, suppose if you want to take that as an NRA, there, the valuation of buffet transactions are very subjective and very difficult to value. So in this case, how do you, if you are saying that if you have to follow Schedule 1, you have to do auction, very difficult to even assign the EMD part, how much will be the EMD, what is the minimum price and all those things. So one suggestion which came was that why don't you invite who are the prospective bidders who wants to show interest, and then between the whatever bidders you get, you have a inter-se challenge mechanism between them, and then whoever is the highest bidder you appoint, and that practice be done in this case, like in buffet transactions. It's only the NRA assets are buffet transactions.
Definitely, Mishra ji, आप इस केस में कर लीजिए. मैंने जो आपको बात की थी, मैंने उनके बारे में कहा था कि जो एसेट्स आपके एसेट मेमोरेंडम के अंदर रिफ्लेक्ट हो रहे हैं. As far as buffet transaction is concerned, is not part of the asset memorandum. Let's make a distinction of asset reflected in the asset memorandum and others. Buffet में तो it's a castle in the air. तो ऐसा लग रहा है तो आप
very subjective, very subjective. Yes.
सर आप दिखा दो ना, बच्चों को दिखा देते हो ना कि ये, यानी कि आई रिमेम्बर यशोदा मैया ने कृष्ण जी को यही कह के दिखा दिया था, ये कटोरी के अंदर चांद है तो इसी को पकड़ ले। तो आप सर ऐसा चांद दिखा के वैल्यू मैक्सिमाइजेशन करिए, बिल्कुल यू कैन गो फॉर दैट।
राइट, थैंक यू, थैंक यू।
I hope I've been able to quench the thirst of all the participants, और participants ने भी मेरी quench को thirst करा, thirst को quench करा। और let's move forward now quickly. Hardly 7 minutes are there. I thought of putting at least half an hour on this thing there, but now not time is there. Okay, practical aspects of guidelines.
The session by 15 minutes to cover up your. Please extend the session by 15 minutes at least to cover up your submissions.
चलिए सर 15 मिनट आगे एक्सटेंड कर देते हैं, नो प्रॉब्लम।
We are willing to, sir. We are with you.
Sir, I'm really grateful for your love and affection to me. Hopefully organizers are also listening. They will allow us for 15 minutes extension, and I try to finish it off in that way. Okay. Chat box के अंदर organizers आप please देख लीजिए. I'm not able to get time to read all the things there. So or anyone else from our participants can look into it, and he can put forward if any pertinent or some questions are there. Okay, let me move forward now. Practical aspects of guidelines for committees of credit. देखिए इसके बारे में आपको सबसे पहले बात बता दूं, I'm going to have a disclaimer in the sense कि ये IBBA की साइट्स के ऊपर नहीं आई हैं, ये व्हाट्सएप ग्रुप के अंदर आई थी, और तो उसके बेस पे
सर ये सर्कुलर में डाला हुआ है उन्होंने, IBBI ने अपनी साइट पे सर्कुलर में डाला हुआ है,
डाल दिया है। अच्छा, मेरे को नजर नहीं आया,
ये डाला हुआ है, नोटिफिकेशन नहीं आया।
ओके
आई हैव चेक्ड इट।
ओके दैट्स ग्रेट। ये कब डाला उन्होंने?
ये मेरे ख्याल से उसी में डाल दिया होगा, बट दे हैड नॉट डिस्प्लेड इट ऑन द
few days before, sir. 2-3 days before I saw it.
Okay. Thanks for enlightening me. Because हमारी वो एसोसिएशन के अंदर ये डिस्कस हो रहा था कि इसका चलिए अब हम इसको आप कह रहे हैं।
I have one suggestion over there, sir.
Yes,
they
sir.
had made
yes,
it that guidelines for committee of creditors. Other
आपकी आवाज चली गई।
They have only mentioned it is guidelines for credit of creditors. Rather, it should have been credit of creditors as well as the SCC members. Because this rules applies for both these.
Actually, आपकी आवाज थोड़ी सी समझ नहीं आई थी, आप प्लीज अपनी बात को थोड़ा सा रिपीट कर देंगे सारा?
Yes, sir. I say that these guidelines are for committee of creditors. Rather, it should have been committee of creditors as well as the SCC members.
चलिए सर, ये तो implied है ही, COC और वैसे भी
They should have mentioned somewhere the motor student is the.
Yes. That's a good enlightenment on your part. कि ये SCC का भी होना चाहिए इसके अंदर, definitely. चलिए, let's move forward. Okay, before that, we at an IPA we are holding events very regularly. Basically, हमारे जितने भी टॉपिक्स होते हैं, हमारे करंट टॉपिक्स ही होते हैं, जिसके ऊपर भी कोई सर्कुलर नोटिफिकेशन आता है, तो आई हैव प्रिपेयर्ड अ लिस्ट फॉर ऑल ऑफ यू, यू कैन क्विकली गो थ्रू इट। यानी कि ड्यूरिंग लास्ट ये तो शुरू किए हैं, नॉट मच रिलेवेंट, इवन ड्यूरिंग लास्ट 1 year वी जनरली होल्ड 2 seminars और वेबिनार्स इन ए मंथ। तो दीज आर दी जो लेटर पार्ट के वो मैं आपके साथ स्लोली शेयर करता हूँ। 2023 ऑनवर्ड pre-pack के ऊपर करा and all this thing there, and we always invite जैसे JP का बड़ा important केस आया था May 2023 में, we invited Anuj Jain there, we invited पूजा बेरी का मैंने PPIRP के ऊपर आया था, we invited there। तो ये these are the things I'm just sharing it with you for your enlightenment।
सर ये फॉर्म जो फॉर्मेशन हुआ है, मतलब आपका प्रेसिडेंट है, हाउ वन कैन बी अ मेंबर टू दिस एंड देन व्हाट इज बेसिकली हाउ इट फंक्शन सर?
सर बेसिकली आर इज अ वॉलंटरी ऑर्गेनाइजेशन। हमारी ये सबसे पहली ऑर्गेनाइजेशन थी, इंसॉल्वेंसी प्रोफेशनल्स की एसोसिएशन थी, और जो अभी तक कंटिन्यू कर रही है, हम इसके अंदर सिर्फ एजुकेशन इम्पेयर करते हैं। जैसे हम इस समय आपके साथ वेबिनार ले रहे हैं, जो भी लेटेस्ट टॉपिक आता है हम उसके ऊपर डिस्कशन करते हैं। और मेनी अ टाइम इंसिडेंटली जैसे किसी के डीसी प्रोसीडिंग्स वगैरह हो जाती हैं, ये आल्सो कंसल्टेंट्स, व्हाट एवर लिटिल बिट और स्मॉल हेल्प वी कैन डू, वी हेल्प देम आल्सो। और किसी को कोई प्रैक्टिकल काम करते हुए कोई प्रॉब्लम आती है तो वी हेल्प देम आल्सो कि इस चीज का जैसे कि फॉर्मेट चाहिए। जैसे पीजी टू सीडी के केसेस अभी रिसेंटली स्टार्ट हुए थे, तो बहुत सारे लोगों के पास फॉर्मेट नहीं था रीपेमेंट प्लान का, सेक्शन 99 की रिपोर्ट का, जो इनिशियल हमारे को ये क्या कहते हैं जो एप्लीकेशन फाइल होती है फॉर एप्रोप्रिएट ऑर्डर्स, तो हम लोग वो सब फ्री ऑफ कॉस्ट वी शेयर विद एवरीबॉडी, with not only with our members but others also many times, but definitely we prefer to share it with our members. So that is
How
all
one
there.
can be, does it require to be a member? Then how can one can be member
Yeah,
to your
you can, यानी कि you can have my telephone number. यानी कि मैं अभी बता ही देता हूँ, प्लीज नोट कर लीजिए। my telephone number is 98
वो तब लिखा हुआ है स्लाइड में अपना।
हाँ लिखा हुआ था, बस ठीक है, आप नोट कर लीजिए।
या।
अब ये सेशन के बाद मेरे से बात कर लेना, जो हमारा कंसर्न बनता है मैं उससे आपको कांटेक्ट कर दूंगा, यू कैन हैव विद इट। प्रैक्टिकली आई टेल यू, आई थिंक हम 5 साल की ये साल की शायद 1000-1500 रुपए की फीस है जो हम लेते हैं, 5 साल की 5 या 6000 रुपए समथिंग लाइक दैट कुछ फीस है। एग्जैक्ट वो आपको कंसर्न बंदा बता देगा कि 6000 7000 फीस है, कुछ ऐसे ही है 5 साल की, या 3 साल का भी एक है, तो वो करके यू कैन बिकम मेंबर एंड गेट बेनिफिट इन योर आईपी प्रैक्टिस।
ओके सर, थैंक यू सर।
मनोज जी नंबर दीजिए।
एक और काम करिए, ये ना यूट्यूब चैनल है, जितने भी मैंने आपको पीछे जी ये वेबिनार्स बताए हैं, ये सारे के सारे यूट्यूब के ऊपर अपलोडेड है। दिस इज आर देयर और तो आप इस पे जाके इन बेसिकली व्हाट हैपन, जैसे मैं आपका ये मेरे को आज आपका ये एनआरआरए के ऊपर ये बनाना था, तो आई आल्सो सर्च सिमिलर थिंग्स फ्रॉम देयर। अब जैसे ये रीपेमेंट प्लान का मेरे को वो फॉर्मेट लेना था कि रीपेमेंट प्लान मैं पीजी के सीडी के इसमें कैसे किसी का करूं, तो आई आस्क्ड माय निपुण सिंह जी मेरे फ्रेंड है, उन्होंने बनाया था हमारे से पहले, तो आई आस्क्ड देम ये डू इट देयर। तो बेसिकली प्रैक्टिकली जब हम काम करने बैठते हैं तो मोस्ट ऑफ द थिंग्स एक दूसरे के इंटरेक्शन से ही समझ आती हैं। उसी के लिए हमने ये प्लेटफॉर्म बना के रखा हुआ आईपा का, वेयर बाय यू कैन हैव इट देयर। यूट्यूब चैनल ये है, और इंसिडेंटली मेरा फोन नंबर भी इसके ऊपर आ गया, मोस्ट प्रोबेबली आप लोगों ने नोट कर लिया होगा, नहीं करा तो मैं एक बार वर्बली बता देता हूँ, 9811280787।
Sir, so Raman here.
Yes, please.
I've uploaded that circular, that guidelines in the
हाँ जी
chat box.
हाँ जी, थैंक यू वेरी मच। चलिए हम आप उसको डिस्कस करते हैं। ओके 6 ओके। देखिए सर, इतने सारे चेंजेस हमारे आईबीबीआई के अंदर आते हैं कि इनके ऊपर ट्रैक रखना, इवन वी रन एज एन एसोसिएशन, वी हैव ए डिफाइंड हायरार्की ऑफ टेकिंग ट्रैक ऑफ ऑल दिस थिंग्स, बट आदि यानी कि यू नो many a time you miss it also, and many a time you it gets skipped out of your mind also. चलिए अब ये I would like it this क्या कहते हैं, पूरे 15 मिनट का हमारा जो सेशन होगा, तो लेट इट बी इंटरेक्टिव आल्सो, बिकॉज ये एक ऐसी एक्सपेक्टेशन है कि हम लोग बहुत टाइम से ये पिछले 3-4 साल पुराने से हम एक्सपेक्ट कर रहे थे कि जैसे कोड ऑफ कंडक्ट हमारे लिए है, ऐसे सीओसीज के लिए भी होना चाहिए। अब वो अल्टीमेटली दे हैव ब्रॉट इट देयर, तो आई होप एवरीबॉडी विल बी हैप्पी विद इट। और इसके अंदर और क्या इंप्रूवमेंट्स रेगुलेटर से हम एक्सपेक्ट करते हैं, तो let you can share it that with me also, or so that we can put forward before authorities, our regulator also. I tell you one thing, our regulator listens to us. Only thing is कि हमारे को जो हमने अपनी बात करनी होती है वो एक legitimate होनी चाहिए। और रवि मित्तल जी, आई एम सो हैप्पी कि he listens to us। हमारी अभी पीछे जी एक रिजॉल्व करके मीटिंग हुई थी, हो सकता है आप लोगों में से काफी लोगों ने उसमें से अटेंड भी करी होगी, दिल्ली के अंदर हुई थी, ये भारत मंडपम के अंदर, प्रगति मैदान के अंदर, वेयर मिस्टर रवि मित्तल ओपनली सेड टू एवरीबॉडी दैट ड्यूरिंग सीआरपी प्रोसेस, कहते वी आल्सो अंडरस्टैंड द पेन्स, एंड अगर आप इनोवेटिव होके इवन एक्सीडिंग योर रेगुलेशन और समथिंग फॉर द बेनिफिट ऑफ स्टेक होल्डर्स करते हो, या फॉर वैल्यू मैक्सिमाइजेशन करते हो, तो IBBI will take care of you. It's not that कि यानी कि all the time what एक general perception is कि वो हमेशा एक stick लेके हमारे ऊपर hover रहता है. It is not like that. He openly said this thing, and we are really thankful as an IP community to them कि that take care for that. चलिए ये हम लोगों की, मैं इसके बारे में थोड़ी सी आपको background बता देना चाहता हूँ. We people were asking for code of conduct for COC for a long, and इसके बारे में जो डिस्कशन पेपर भी आया था, वो भी काफी पहले आया था, जो मैं अभी आपको बताऊंगा. तो लेकिन आरबीआई का काफी प्रेशर था आईबीपीआई के ऊपर, वेयर बाय दे वर स्टॉपिंग देम टू इशू कोड ऑफ कंडक्ट फॉर देयर मेंबर्स. तो बिकॉज अब प्रैक्टिकली सीओसी के अंदर मैक्सिमम ये पब्लिक सेक्टर बैंक्स ही होते हैं. तो बट अल्टीमेटली कीपिंग द ब्रॉडर ऑब्जेक्टिव इन माइंड, IBPI has come out with all this thing. तो इसके अंदर क्या क्या है, लेट्स डिस्कस. We all welcome long-awaited COC so-and-so as on so-and-so. After a period of 3 years, again generally 5-6 months taken in issue of discussion papers and subsequent issue of guidelines against it. Please note that discussion paper on COC was issued on so-and-so. Let's analyze details as follows. Preamble at point number 2 says that most of them are under regulatory oversight of the financial sector regulator. In fact, that was the main saying from the RBI to the IBPI, that हमारे जो COC के members are, they are already under their regulatory framework, hence they don't require any more code. But practically, our question is, are the banks acting against their officers when an account become NPA? But it is expected that IRP, RP liquidator should get a recovery from the NPA account. Second is that preamble at point number 3 says that foster more effective and time-bound decision. But practically decision making process is very slow. The main grudge is as follows. Junior level staff is asked to attend the meeting, who always ask for time for decision making, as all decisions are taken by competent authority, who sits hardly 1 or 2 times in a month. I'm talking about this for the SBI. For private banks and other banks, it might be different situation, but SBI, who's the biggest COC brother, decision making is very there. इसका नुकसान क्या होता है? नुकसान इसका ये होता है, they always practically ask us for repeated extension of voting. They ask us of revision of minutes of meeting based on their queries they receive from the competent authority for all this thing there. And we, respecting our big brother, always come under their pressure and extend our voting time and all this thing there.
So there should be upper gap for voting, sir. Extension. 3 times होना चाहिए. इसके बाद no extension.
Even in the amended regulation, they have not put the upper cap. They said that अब जब भी किसी को ये extension करना होगा, CA to simply make a request to the COC there. That is there. बिल्कुल ठीक कह रहे हो. I agree with you. Let what basically our purpose is. We are practically analyzing कि जो ये guidelines या code of conduct COC के लिए दिया गया है, इसके अंदर क्या क्या चीजें missing है. जैसे आपने एक बात ये करी, तो let COC be asked to make जो चीजें cover नहीं करेगी इनके code and conduct के अंदर. Payment is always a big problem. You have to run after if by chance you don't have any money in the COC in the
half the time taken or the extension time taken will be excluded from the IBC total time. Whenever 7 days is given for COC to decide voting issues, they indefinitely ask for extensions. Whether the time is to be excluded from the total time. It is not a delay by the IP.
Sir, होता पता क्या है? जो ऑनर होता है ना, COC is the honor of the CD. जो ऑनर होता है तो कहते हैं ना, वो जो गाय दूध देती है उसके नखरे झेलने पड़ते हैं. तो you treat it like that. You have to bear their tantrums in that way. Whether delays on their part or your part, it will be treated as a delay only on your part. चलिए, I'm talking as per law.
They also not decide. Even after taking time for voting, they not even decide on the item. They defer or abstain.
Absolutely.
Again.
That is why I have taken it in my presentation in my slide, that this thing should have been covered in the guidelines from the Committee of Creditors, that they whatever practical situation is there, they be asked to not extend voting lineup. but for which they have not mentioned anything. They should not be asked to revise the minutes and all this in there. चलिए हो सकता है रिवाइज गाइडलाइन आ जाए उसके में हमारे से जब बाकी लोगों से सुन के IBBI may come out with there. Okay, you know, one very big complaint I received from especially from the new coming the IPs is that you know, they are not able to get empaneled with the banks. Reason for that is there that every bank nowadays asks for some experience, something there, and every new IP is not having there. For that, we have suggested, in fact, I have been suggesting personally also, and through our association also for the last 3 years, that let the empanelment system with the bank be, be scrapped. And for that, we have given them the advice that in our CF firms, we are being allotted branch bank audits all over India by so many CF firms, which are running into approximately 3.5 lakh now. And maybe with IBBI, sorry, RBI, more than 1 lakh is there. And even if, and so many similar sort of, 2 lakh branches are there, or 3 lakh branches are there all over India. Let them, IBBI take control of allotment of assignments of IRP, RP through this way. But till that, nothing is happening. And that is, here I mean to say that as far as empowerment is concerned, some guidelines should have been also issued on their empowerment. Basically, it is replica of code of conduct of IPS. Let's examine each guidelines now. 5:10 हो गए, sir. I need to, complete it. My first guideline is related to objectivity and integrity. Point E says follow relevant provisions of the code and regulation in letter and spirit. Are these followed? As an example, circular number so and so, which was issued, 6 years ago, 10th of August 2018, which specifically said that tenders by a COC member of such persons were competent and authorized to take decisions on the spot without differing decisions for want of any internal approval from the financial creditor. It has never been followed in letter and spirit. Now, guideline number 2. Here point number B is also there to maintain objectivity. Objectivity of IBC is resolution and value maximization. But practically, they treat us as only recovery agents. Point number C says share relevant information. It's very hard not to break from them, but hopefully now, with these guidelines, we can say to them that this code is applicable to you also. Please share your stock audit reports, transaction reports, forensic reports, pre-sanction evaluation reports, quarterly reports, etc. with us so that we can have a better look of the CD. The second guidelines is related to independence and impartiality. It is being maintained. If anyone else among you have contrary view, please share it with me. In my opinion, it is being maintained. The third guideline is related to professional competence and participation. Nominate with sufficient mandated approval of the competent authority. Sir, I've written it red. I don't have the guts to speak in front of you. You can read it. The third guideline is also related to cooperation, supervision, and timeliness. Lot of hue and cry made in IP words group for supervision by IPs. Section 27 always give them enough power of supervising us, because whereby we can't do much work there. And as far as liquidation is concerned, now regulation 31A is very strict, whereby all the work need to be done with the consent of there. But that should have been taken care in the guidelines also. But chaliye, koi baat nahi. Facilitate expeditious appointment of various professionals. Generally, they allow, and now new trend has developed appointment of for a period rather than for the whole tenure of assignment. Except they insist for opening. The one thing that I'm finding is that all financial creditors insist कि bank account जो है liquidation account उन्हीं का यहाँ पे खोला जाए. And this has been told to the IBBA many times also, but nothing has come out to be there that whether they should not insist on it there. The fourth guideline is related to confidentiality. It is maintained. The fifth guideline is related to cost. Issue of prompt payment not addressed, rest is okay. Yeah, we have already talked. The sixth guideline is related to beating of COC. It states regularly monitor the activities of the insolvency professional and seek rational of decision actions taken by him. Being regularly done, Code 28 gives them statutory powers, whereby RP is supposed to do the things only with the consent of COC. That's all. It states related to belated claims. They have issued some guidelines related to the belated claim. But I don't find anything there. This is a welcome step. Hardly any COC member interface, and all is left to the vision of the RP. If you have any contrary view against that, please share it there. It states to proactively share the latest financial so and so and so on, so and so. Practically, it is not being shared. Now we have a right, statutory right based on these guidelines to ask them कि भाई इसको जरा timely share कर दो. And we face a lot of difficulty when we prepare repayment plan under Section 105 Part 3, whereby we need to see what assets they have, the PG have, because whenever they take a grantee, they take details of their assets also in the form of statement of affairs and other things also. And whenever we ask them to share that with us so that we can prepare a effective repayment plan, they hardly are able to, provide it there. Now with these guidelines, we can assist them and request them कि sir अब तो law ने भी आपके ऊपर mandate कर दिया, तो you do share it with us. This is all I have with you. Hopefully 5:15 is the time also. As I promised, we are concluding our session at this time. Thank you very much.
Sir, could you be able to share the PPT?
मैं अभी इसको शेयर कर देता हूँ जी, ये इसके ऊपर
Sir,
अपनी
you will
chat
get the
box के ऊपर.
PPT. Everyone will
You
receive the
yeah,
meeting, sir.
then let organizers share it there, because it might be of a little bit big size.
Thank you, sir.
With this note,
Thank you so much, Manoj, sir.
Thank you, sir.
end our meeting.
Thank you very much.
It was a very useful practical session, sir.
Yeah, because theoretical तो हम सब लोगों को आता है. We can't enlighten each other. We all are aware of what Section 37A says, what Section 38 says to us, what relevant section of the code says to us. In our webinar, my objective is to let's share each other's knowledge so that we can take solve our problems and solve our difficulties in a more effective and more enlightened way. That is always my purpose of webinar, whatever we hold. In IPA, we hold generally 2 webinars in a month, and this is I request to my all speakers also, whomsoever we invite there. With this note, we end our meeting. Thanks a lot.
Sir.
Thank you
It was
very much for
nice.
joining me.
Thank you, sir. Very, very,
Very nice. We are very happy, and I got so many questions on NRRA. Before asking itself, in the next slide, the answer is coming. So the program is structured in such a way that I need not ask a single question. And you hit the bullseye, sir. Whatever the practical challenges we are facing, simply you made it very simple. We are very happy, sir. Thank you.
फिर भी कभी आपको कोई दिक्कत हो, कुछ भी हो, you got my telephone number. जितनी मेरे को समझ होगी, जितनी मेरे को my knowledge will be there. I would love to share with my professional colleagues. That is a passion with me. You always are welcome all the time.
So nice of you, sir.
You can become members, na, sir. All India Insolvency Professionals.
हाँ जी.
Thank you.
Can I make a request? I request to Manojji that kindly speak in English only, because we are all from all over India.
So, sir,
since you are sharing the presentation, we will read it and understand. But hearing from you is more valuable than these papers.
Yes, sir.
Mr. Nair, I'm really grateful and thankful to you. But I tell you one thing. What happened is that we people are from the Hindi belt, but we also learned English. You people also, it's 75 years of our independence is already there. थोड़ा हिंदी सीख लो सर. हमारे अड़ोसी पड़ोसी जितने भी आपके एरिया से है सबको आता है. And we, it's in our gene that we North Indian people always talk in Hindi plus English. That is called Hinglish. So, but even then, I would like to speak in my future webinars. I shall take care that I shall speak maximum in English.
Absolutely right, and thank you for the guidance also.
Sir,
thank you so
lastly,
Thank you, Anand.
so actually, someone asked me that what are the Supreme Court judgments or High Court judgments in relation to non-payment of stamp duty, or maybe non-requirement of registration, non-requirement of registration in case of sales certificate issued under SURFACE.
Yeah,
So I've already shared.
You posted that High Court. Yeah, Chennai High
Yes,
Court
yes.
case you posted. Thank you,
I
sir.
have already shared a very comprehensive article in the chat box itself. So that very article can be downloaded, and it provide all the judgments regarding the SARFAESI Act, and this has been categorically decided by High Court and the Supreme Court that stamp duty payment is not required. Moreover, registration has to be done under the Registration Act as per Section 17, Subpart 2, read with Section 89, Subpart 4 of the Registration Act 1908. So this is very much good.
थैंक यू वेरी मच संदीप जी। यही हमारा ऑब्जेक्टिव होता है कि हम लोग एक दूसरे को एनलाइटन करें। देखिए, नॉलेज एक ऐसी चीज होती है, जितना हम इसको शेयर करेंगे ना उतनी बढ़ेगी। अब मैंने आपके साथ नॉलेज शेयर करी, मैंने नॉलेज आप तक नहीं शेयर करी, मैंने आपकी नॉलेज ली। My objective is I have extracted knowledge out of you, and ये मेरे लिए कब बेनिफिट हो जाएगी, कब हो जाएगी, only God knows. But thanks a lot. Thank you very much, especially to Sandeep ji for sharing his knowledge and enlightening all of us. अंजुमन जी, आप म्यूट करिए अपने आप को। अंजुम जी म्यूट करिए अपने आप को। चलिए, कोई बात नहीं,
म्यूट करिए।
चलिए, we are at the fag end of the session. So thanks a lot. Thank you very much to Sandeep ji and others also who enlightened us, and thank you to all those also who questioned me, because of that only I was able to understand कि मेरे में भी कुछ थोड़ी सी knowledge है. Otherwise, I'm like you only.
Thank you so much, sir.
So let's meet in some other session with each other. Thank you very much. With this, I'm leaving the meeting. Thank you. Okay, ji. Bye bye.
Thank you so much, Anand sir.
Thank you.
Thank you, sir.